Judge Rachel Klaus is presiding. Court comes to order.
Good morning. This is Smith. We have the jurors filtering in, but I know we have some preliminary matters to take out. Mr. Fawcett, are you going to handle this by yourself, or do we need to give you a minute to find Ms. Hilton and Mr. Wilson?
I would like to assist this judge, but I'm ready to go.
Okay.
Thank you.
Here we have a second part.
Morning.
Okay. Madam Court Reporter, you ready? Yes. Okay. This is going to be day 3 of the trial of Christopher Wolfenbarger, case number 24 SC 004201. I'll note for the record that we seated our jury yesterday and that they are filtering in ready for a start time of 10 a.m. Mr. Wolfenbarger is present here in the courtroom along with his counsel, Mr. McDermott and Mr. Samuel, and the state's counsel, Mr. Fawcett, are also present. We had some preliminary matters that we needed to address this morning. I had wanted to follow up on audio and photographs that we were still working through in terms of what's going to be offered. Mr. McDermott, had you had a chance to get through those materials?
I have, and I emailed Mr. Fawcett last night.
Okay. Do we have agreement on what's going to be offered?
We do not, Your Honor.
Okay.
I did take out photographs that defense counsel felt as though they were duplicative. I took out photographs that displayed the victim's skull. There's one that displays the location of the skull. There's several others that show different angles of it. I've eliminated those as part of my intent to show the jury the location and corroborate the evidence in the form of testimony. But this is a case where Ms. Wolfenbarger was, her remains were left. We know at least the extremities were out there in the elements for at least a 2 to 3 month period, because you have the skull found in April and you have the extremities found in June. And so that, just by the very nature of that, is going to lead to pictures that are less than pleasant. But there are only 2 photographs of her extremity that were located in the woods on that June date. Obviously, there could be several of those photographs, but there are only 2. The autopsy photographs, we have eliminated several, and the intent of the autopsy photographs is to show some of the tool marks. But we anticipate testimony from our anthropologists as well as our medical examiner to say that they observed what they believe some type of mechanical device, man action, that was used to separate the skull from the neck and the femur bones from the torso. And so all that's relevant evidence, and the markings on that show the jury the marks that would be testified to, as well as corroboration of testimony. And I would submit to the court Davis versus the state. That is a Supreme Court case, 306 Georgia 140, 2019 case, specifically deals with defense objections as to the gruesomeness gruesomeness or objectivity, prejudicial effect of crime scene photos and
Right.
homicide cases. in particular.
Yeah, and I mean, and let me save y'all some trouble. I am not of the opinion that just because things are gruesome that they are somehow prejudicial. If they're relevant, then the court will conduct an analysis under the appropriate rule of whether it's overly prejudicial, as is required. I think what I was hoping for is more to avoid accumulation, right? And so that what you're presenting is the evidence that's necessary and relevant to your case, and not, let me show you 9 pictures of the same gross thing that we all really don't want to look at when maybe 1 or 2 would suffice. That's really all I'm trying to accomplish here. And if you're going to show 9, I want to make sure there's some particular reason that that's necessary and that I've conducted the analysis I need to ensure that it's not overly prejudicial if that's what you're doing.
Well, if I can split these up, and I'm
Sure.
going to start with the autopsy photographs.
Okay?
If I'm looking at the autopsy photographs, the intent was to show each different section of the body that was discovered, as well as the tool marks that would be testified to.
Okay.
I do not believe there are any duplicative photographs of any one particular part of the body that was located. I don't believe there are any duplicative photographs of any of the tool marks as it relates to the images I intend to show from the autopsy photographs. As to the crime scene, obviously there are going to be photographs of what the crime scene looked like without the body there, because the body was, was being transported, the remains. But it's important for the jury to have a context of where the location of the skull was located. There will be some testimony that they believe that there were dogs that were carrying the skull, or a bag they believe the skull was in, from the wooded area where the extremities were located to the street where the skull was found. There's going to be testimony that that same dog had to be shooed away. And I think that as far as where the skull was found, where the sewer is, and the proximity of that to the job, I think is particularly relevant. And I think specifically as it relates to that Davis case, specifically crime scene photographs that are indicative of the location of where items, where relevant items are pertinent, and although they may be prejudicial, I hope everything that I present is, that prejudicial effect is not outweighed. I think that this evidence is relevant, and I think it is necessary for the jury to see some of the photographs. And I mean, I guess ultimately what I'm saying is, I don't have any issues taking direction from the court. You're the fact finder, so if you independently feel as though a certain portion of the photographs don't need to be played, that's fine. But what I got from the defense, I think, was limited in what they were willing to agree to. I didn't feel like that would have been representative of the case.
Okay. Thank you, Mr. Fawcett. So, Mr. McDermott, let me ask a couple of questions as you begin your argument. So, I'm assuming for your record you want to state your objection to all of them. Is that fair?
No.
No. Okay. Well then, because really what I'm trying to get down to is if we assume that some universe of those photographs are going to come in, then what I'm trying to get to is what are the particular aspects, which particular photographs do you object to and why?
Well, I sent him the list last night. It was my understanding he was going to submit all that to you and go
Okay.
through them one by one. But it really, what he described is actually what my point was. I'm not objecting to showing a head in the road as it was found. I mean, that's obviously relevant and important to the crime scene. As far as the discovery of the limbs a month later, there are only 2 pictures of that. One limb and one black bag. Well, I take that back. There are a couple of other black bags. I don't object to those. When we get to the autopsy photos, I understand we need to show tool marks because they're going to testify this was a saw, and we'll have a discussion about that. But do we need to see this is the left foot? No tool marks involved. Nothing about the crime scene. Nothing about cause of death. Nothing necessary to explain anything the medical examiner did.
So,
And then now the right foot. Let's look at the right elbow. Let's look at the
right. No, I understand that, Mr. McDermott, but I mean, setting aside that we're talking about body parts instead of one entire body, I mean, it is fairly standard to show for identification purposes, these are this is the body that was delivered to us, and after we cleaned it up, the condition that it was in. And usually the arguments I'm having are, but please don't show where you took off the front of their face to inspect their brain. And so I guess if that's the typical way that it's presented, then why would, here's the left foot, here's the right foot, here's the right arm, here's the left arm, here's the skull, at least those minimal baseline photographs, why wouldn't they be admissible? Why would they be overly prejudicial or not relevant?
I think the repetition of it, but in addition to that, we have multiple pictures of the bones after the flesh was, as we understand it, steamed and cooked off of it. That is not necessary for them to determine anything. The tool marks were visible without that. Why do we need pictures of the bones laid out in an array? So if we could just limit it to what is absolutely necessary to get it across, I think that would be helpful.
So to that end, forgive me, I'm going to let you continue making your record, but to that end, I think what needs to happen then is, Mr. Fawcett, if you have a list that was provided to you from Mr. McDermott, if you can just email that to me so that I can take this flash drive. Are the exhibits identified by exhibit number on this flash drive, Mr. Fawcett?
Yes, the exhibit numbers are listed on the exhibit.
Okay, so I should be able, what my intention is to go through and look at the ones where Mr. McDermott has asserted an objection, where the parties don't agree, and then just go through, and then I can go through them one by one and provide you with rulings on their admissibility.
And let me just add, as far as the flash drive goes, it's one PowerPoint file, and the numbers of the exhibits correspond to the numbers of the slides in PowerPoint.
Thank you. That's very helpful.
I just also want this put on the record that there's I don't know what to call this. This is a printed out list of photographs that was included in the original discovery. I have never been able to find out who created this document, and we have never been provided with these photographs. There are multiple photographs clearly describing the crime scene where the limbs were found. And by my just looking at it, probably about 36 photographs. And I think that would actually be more helpful than the autopsy photos. But I would just love to find out who compiled this list so I could cross-examine them. And I've been asking for that for several days now. Don't get an answer, so put that on the record.
Mr. Fawcett?
Yes.
You're gonna email me the list that you and Mr. McDermott have exchanged?
Yes, Judge, I just did that.
Okay.
You should get that. And so I think when we first started at the arraignment for this case, I know the court referenced how old the case was and how sometimes there may be documents that may not be able to be produced. When we first indicted the case, we went over to the Atlanta Police Department, the annex, to retrieve and physically view the files. Before the case was indicted, I went over to the Atlanta Police Department and reviewed the officer's original file. We did that again a month after the case was indicted, just to ensure that we were complying with the court's discovery request. I believe that was required for the end of that year, I think 2024. And shortly after that, we got a request from the defense. I offered for the defense to come to our office to view our discovery. I think after we had the motion to compel, I advised the court that I had offered them to do that. I made another offer to do that. And I made a third offer in writing, email to Mr. McDermott, I think maybe 3 weeks ago. Last week, Mr. McDermott emailed me and asked me what day would be a good day to come over and view our file. And my intent was to make the Atlanta Police Department lead detective's file available, Detective Shepard. My intent was to go back to the annex. I know how important this case is. Go back to the annex and look at it again. Part of doing as much due diligence as I could. I offered Mr. McDermott, I believe Tuesday and Wednesday of last week, to come over and view it. When we talked we discussed the discovery. We didn't discuss that date. I assumed he no longer was interested in that. But I've looked in every file that we've had. I've looked at the annex. I've looked at our digital files multiple times. And every document that we have in physical paper form and digital form has been turned over to the defense. I don't have any other documents.
Okay.
My complaint is not that I don't have enough documents or that these photos are missing. I can understand that that's the case. I just want to know who made this document and can I call them as a witness? And that's not unreasonable. They have access to Mary Beth Hoptel. They have access to T.R. Miller. They have access to all the investigators who worked on this back in the Calhoun days when this would have been created. And they can surely find out who created the list of photographs and their descriptions so that I can cross-examine them.
And yeah, I did inform counsel that there were 2 investigators that were working on this case. It was Mike Alsip, whose name is in the discovery, whose name is on several...
Hang on, let me back up for a minute. Do you know, is the issue that you don't know who created that document?
I don't know who created that document, but I can say that
Right.
there were
Okay.
2 investigators that could have created it.
Sure.
Alsip, Mike Alsip, who was an investigator with the Fulton County Medical Examiner's Office, and investigator Tina Miller, who is on the witness list and going to be testifying, who was also an investigator. That's an investigative report, and there was one of those 2 investigators made that report.
Okay.
I mean, I guess I can wait till she's on the stand and roll the dice. And
Well,
ask-
have you had an opportunity? I mean, I assume those individuals were identified to you either specifically as people with information
Yesterday.
or on documents that were in the file in terms of reports that would have been provided through discovery of their involvement in the case.
I mean, they have been on the state's witness list. But
Okay.
as far as their involvement with these documents, I didn't know, and I learned that yesterday.
Okay.
I still have time to try to call them between now and then, although I think T.R. Miller's scheduled to testify today. So.
Okay. So here, I think that if the state has identified that they don't know who created that document, but that it could be either of 1 or 2 people, and those people are identified as witnesses, or through their role were identified in terms of their involvement in the case, that they've been identified sufficiently for purposes of discovery, and that to the extent that one of them is going to testify, I don't think it's unreasonable for you to ask to, inquire with them before they take the stand, hey, is this a document that you created?
Go ahead. Those names were mentioned to me yesterday. I was not told, we don't know who did this. You'll have to pick from these people and find out for yourself. I was not told that they didn't know. I was under the impression that they were still going to try to find out for me.
Well, I understood from Mr. Fawcett's answer that he did try to find out, and he hasn't been able to find an answer, that it's got to be one of these 2 people.
Then there was
But-
lots of communication yesterday.
Well, Your Honor, I think co-counsel has a suggestion. I'll reach out to the original detective, Calhoun. I'll forward these to him to see if he can assist. He may have the name of a crime scene detective would have created that document.
Okay.
I'll do that.
Thank you. Anything else on the topic of photos for now, Mr. McDermott?
Not those photos.
Okay. Well, there were 2 sets of photos we were talking about. One was the list of photos that has not been produced to you, that Mr. Fawcett says do not exist as far as he's aware, digitally or in paper. And then there was the second set, which are the ones on this flash drive that I'm going to look at and rule on. I have now received Mr. Fawcett's email regarding the ones they intend to offer that I need to actually look at in terms of your objections. Any other issues on photographs that we need to address?
I'll just say yes because Mr. Fawcett just gave me this morning a stack of new discovery. And, well, about half of this is stuff that's old discovery, and about half of it is new discovery that would have been nice to have even just a week ago. But these are cards and letters and photographs written between Norma Patton and allegedly Melissa. And, I mean, it's just dumped on us right before trial, so that's a discovery violation in my opinion. I've heard tale of these cards and letters for ages now.
I believe I heard you during pretrial argument say where are those cards? Where are those letters, right? So,
Recently? Yeah.
yeah, on Monday during pretrial, when we were talking about statements
Well,
by.
it's nice to have an answer to my question. I agree with you. But it's still a discovery violation. That should have been turned over. If they existed, which they did, that should have been turned over a long time ago.
Okay, and we can talk about that when you're ready to talk about that. But those aren't photographs, and we're not talking about that just now.
Well, there are photographs in there. So.
Okay. But I'm assuming not the graphic ones involved in
Well, I was
Ms.
trying to be
Wolfenbarger's
clear that
death.
It doesn't pertain to the foreground. I'm sorry, that's my fault, and I'm being a bad boy. I just admit that's my fault. You said any other photograph.
Sure.
I made that jump. So.
That's fine. What about the audio of Mr. Wolfenbarger's statement? Have we agreed on the portions that will be played for the jury?
I think we have an agreement to maybe 80 or 90% of it. There's a portion we've agreed to start at 15 seconds earlier. I'm agreeable to redact and a part in the middle that counsel has requested. There's a part towards the end where the lead detective is asking a question and he is indicating his theory about where the skull was possibly washed out of because it was rain the previous day.
The detective is saying that?
The detective is saying
Okay.
that to Mr. Wolfenbarger, and Mr. Wolfenbarger responds the way he does. But I think there's other evidence that the skull was likely dragged out of the wooded area. So counsel is requested to redact it. I don't think it needs to be redacted. I think of scenarios where officers ask and make all types of statements to defendants to elicit a response or to see if there is a response. I don't view that as any different. If Detective Shepard and Detective Layton are asking Mr. Wolfenbarger a question, even if they are misrepresenting the crime scene, courts have said that it's not to say that that was the intent of what was happening. Courts have even approved officers lying to defendants or suspects. So I don't think that this is a situation where that was taking place, but certainly, even if the crime scene was not in line with other theories, question about that to the defendant shouldn't be excludable just because it may not line up with other theories. It still elicits a response from the defendant that I think it would be relevant for the jury to consider.
Mr. McDermott?
Yeah, my concern with that particular statement is not that it's just some random theory of the detective. He's not telling a lie. There are some speculation in the early police reports that there may have been a weather event that washed the head out into the road. It clearly was picked up and used by later detectives. For example, Detective Shepard has used that theory when speaking not to Mr. Wolfenbarger, but to other witnesses as explanations for how the head may have gotten there. So clearly this is something that was important to the investigation, and they weren't treating it as a lie to try to get a reaction. And particularly Sergeant Layton's statement in that video is correcting or trying to help Christopher with his understanding at the time, and he says, "It is my understanding that there was a strong flood of water that washed this out into the street." So that's how it got there. And he says it in such a way that I'm afraid the jury will take that as evidence that something happened. He says it in such a confident way that it's his understanding I think it will confuse the jury.
Is that individual going to testify?
There are two individuals there. The Detective Layton is not scheduled to testify, but Detective Shepard was there. He's on the video. He introduces himself to Mr. Wolfenbarger and is present throughout the entirety of the interview.
Okay.
So that was my second point I was going to make, is that Sergeant Layton is not on the witness list, and he's not going to be available to testify on that point. So I just don't want the jury to get confused about that. So at the very least, if we don't redact that, if the court would provide some limiting instruction on that point.
I'm not sure what the limiting instruction would be. It seems the reason I asked about whether the witness or some witness could testify about the circumstances of that statement, certainly with knowledge of the investigation, is that seems like a topic for cross-examination.
Okay, fair.
In terms of whether that was accurate or whether you have information indicating that it was accurate. So I am going to the extent there was an objection as to that particular question, I haven't heard anything that would require it to be removed currently. The objection, as I said, is more subject to a subject for cross-examination of a witness that would testify about those conversations. Given that ruling, if we then have sort of a universe of agreed upon audio, if y'all can please reduce that to some secondary exhibit, which will be what's played for the jury, with only those items that either the parties have agreed or I have ruled will be admissible, that can play as continuously. And then, as I said, when we're ready to play that, I will instruct the jury that there may be, jumps in the video. There may be things, it may appear to them that things have been removed, or that it's been edited and that's been done at my direction, and that they're not to draw any conclusions from the fact that things have been removed from the video or audio, and they're not to speculate about what might have been removed when it's time for that to be played. What exhibit is that going to be, Mr. Fawcett?
That is going to be, and I do have a list for the court. I just wanted to see what the ruling was. Let's see. That is going to be Exhibit 30.
And so y'all are going to have an Exhibit 30A, which is just the relevant portions that we've agreed on. Is that right?
We can do that. Yes, Judge.
Okay, thank you. As I said, what I'm just trying to avoid I'm going to start it and stop it, and then I'm going to start it and stop it, and we just have something that we can agree to play. It is more efficient. Okay, couple of other issues. So I have spent a good bit of time with the forfeiture by wrongdoing issue that was raised by the defense. Specifically, I've already ruled that non-testimonial statements that Ms. Wolfenbarger made to family and friends, that those family and friends can testify about those statements. There is the secondary issue, though, was that there are as I understand it, there are statements made by Melissa Wolfenbarger in court records in service of a TPO application and to police officers as part of, I think, an investigation into that initial event that occurred, I think, on Brookline Avenue, if I'm remembering correctly. And that those are, I think everybody agrees those are testimonial in nature, and therefore they implicate the confrontation clause. And the state's argument is that those statements, that Mr. Wolfenbarger has waived his confrontation rights as to those statements because of his wrongdoing in causing the absence of Ms. Wolfenbarger. So as I understand that provision, it isn't just that the defendant, that the state can demonstrate by a preponderance of the evidence for purposes of the application of this exception, that the state can demonstrate by a preponderance of the evidence that Mr. Wolfenbarger may have caused Ms. Wolfenbarger's absence. It's that they have to demonstrate that second piece, which is that the purpose of the causing the absence was to prevent the testimony. I don't have it up right now, but what I located, I looked at a bunch of case law. The most recent one I saw was from Judge Dillard in the Britton case. And I found that to be particularly educational because what Judge Dillard does is spends about a paragraph explaining the circumstances of that witness going missing, and that was satisfactory to the Court of Appeals that the defendant may in fact have caused the person's absence. But then importantly, they add a sentence that says there was evidence in the case that the defendant had made a statement to, I think, a cellmate that that the defendant was not worried about that witness testifying. And I think that's the concern I have here, is that we have evidence that the state absolutely can satisfy by a preponderance of the evidence that Mr. Wolfenbarger may in fact have caused Ms. Wolfenbarger's absence. What I'm not sure I have is evidence other than potentially an inference from the circumstances, but that inference has to be reasonable to satisfy the preponderance standard, and I'm not sure I have enough. And so based on what I have heard so far from the state, I don't believe that they've satisfied the burden to demonstrate the forfeiture by wrongdoing standard. And so, as I said, to be clear, I believe they've satisfied and demonstrated by preponderance of the evidence that Mr. Wolfenbarger may have caused Ms. Wolfenbarger's absence. But I've not heard evidence that either establishes or from which the court could draw a reasonable inference that the purpose of that absence, the purpose of his alleged action in causing her absence was to keep her from testifying against him in the domestic violence or TPO matter that was pending at the time. And so that's going to be my ruling. Mr. Fawcett, do you want to make a record regarding that issue, sir?
Not necessarily, Judge. I accept the court's ruling. I do have several exhibits that are certified that are representative of that criminal case, such as the petition. There's a Rule 9 size setting the court date down. There's an order restricting contact, and then there's a request for dismissal by Ms. Wolfenbarger. I would still believe all those documents are relevant. What I would still be asking the court to allow the state to tender those into evidence. I would not be publishing the portions of those documents where Ms. Wolfenbarger's laying out the testimonial statements.
Right. Well, I'll hear from Mr. McDermott, but on its face, I agree with you that the existence of that case is not a matter, it is subject to a different hearsay exception that would allow potentially its admission, and it would seem to be relevant. But we were talking specifically about the statements of Ms. Wolfenbarger to officers and or in those documents. Mr. McDermott, your thoughts on that issue, sir?
Well, we would like to see his proposed redactions.
Sure.
What he wants to do, and be able to talk about that perhaps over lunch.
Mm-hmm.
And go from that point.
Okay. I mean, I'm not ruling that they are admissible because no one's asked me specifically, but as I said, at first blush, I tend to agree with you that those would be relevant and potentially admissible under different hearsay exceptions. Anything else that, there was a motion in limine that was filed by the state, I think last night. And I need some help with it because I wasn't quite sure I understood what we're trying to limit. Obviously, we've understood for some time now that the fact that Carl Patton is a convicted murderer, right, was going to come into evidence in some manner, right, that was going to be an issue in this trial. So I'm not exactly sure what you're asking me to allow or to forbid. Can you help me, Mr. Fawcett?
So I guess as laid out in the motion, just as of the past week or so, I think it kind of gives me some insight into what possibly could be asked or attempted to elicit during the course of the trial. And as I've laid out, the only reason why Ms. Melissa Wolfenbarger's father is relevant for this case is because his arrest really jump-starts the identification of her. And I don't know when she would have been identified, but for the infamous arrest of her father and him saying, "Find my daughter," that's pretty much what we've heard repeatedly by the medical examiners, the lead detectives, and everyone involved. But to take that information and now to attempt to introduce letters from Carl Patton, what I'm trying to avoid is a relitigation of the case involving the Flint River killer, because all the particulars of that case simply aren't going to be relevant for the determination of whether or not Christopher Wolfenbarger murdered his wife. So it's one thing to say, well, he was arrested. It maybe is relevant what he was arrested for. Maybe. But outside of that fact, and the fact that that arrest triggered the identification, that's what the detective, Bruce Jordan, was the notifier to the medical examiner's office of that missing woman, Melissa Wolfenbarger. That triggered the retrieval of the dental records from William Brantley. And that was the comparison that made the identification. So outside of that, what other relevant parts of the case would be admissible? I don't believe that the statements of Carl Patton would be admissible. I don't believe that the particulars of the case itself would be admissible. So I don't believe that the defense should be able to ask Norma Patton, well, tell me how many people did he kill? Tell me the circumstances of that. How is that relevant for whether or not Christopher Wolfenbarger killed Melissa Wolfenbarger? It just is not. And I think that in particular is something that confused the issues in this case that confused the jury.
Okay. Mr. McDermott?
We disagree, Your Honor. We think that the only point of relevance being that he helped them identify who she was is just the tip of the iceberg. There's an entire developed body of case law which has been even more developed recently by the Supreme Court regarding evidence of third-party guilt. This is a classic whodunit case. The state has only circumstantial evidence that Christopher led to the death of Melissa. We have substantial evidence that there could have been other people who were involved in her death. And the Supreme Court has recently said the standard for third-party guilt is basically going to be 401, 402, 403. And they have telegraphed that in their most recent opinions. Even though it's not the precedent, I'll grant you, they've telegraphed that. They've said the test is going to be, if this evidence makes it likely, tends to make it likely, using the relevant, I got it top of my head, the rule for relevance, more or less likely that he's guilty,
right? Yeah.
then it's relevant. And then it's only a 403 test after that. Well, Carl Patton's murders, it's not just he killed 5 people back in the 70s and that was it. It's why he killed people. It's his motives for killing people. It's who he killed, his friends and family, the way he killed them, wrapping them up in bags and dumping them in the river. It's the fact that he drove miles and miles to try to hide bodies. It's the fact that Norma Patton, who's going to be testifying here today, was right there hands-on helping him for 2 of those murders. She helped him, and what I intend to ask her about is only what she testified to in court. It's a certified court record that she helped. She helped plan the murders. She helped watch. She was in her living room. They shot the people. They fell. She helped clean up the blood. She helped carry the bodies out.
So let me stop you for a second and set what I think are going to be 2 signposts here before we get more granular, right? One is the fact that Mr. Patton exists, that he is a convicted murderer, that he, I think, was briefly considered a suspect, although my understanding is obviously the state changed its mind and decided that it wasn't Mr. Patton. But all of those things are relevant, and I think that the state can't limit the relevance of Mr. Patton's existence and his history, right? Like how it's relevant to Melissa Wolfenbarger as a general proposition. Also, certainly, I fully expect that if Ms. Patton, Norma Patton, takes the stand, that there will be a thorough and sifting cross-examination about her involvement as a credibility matter, right, and as a convicted felon or whatever, you know, charges she pled to. All of those things I think are absolutely going to probably come into evidence as a general proposition. What I'm concerned about is that part you were just talking about in terms of satisfying 403, from a basic relevance perspective, and to avoid getting too far afield of the issues in the case. Is my general feel is I don't really want to get into relitigating the circumstances of the murders that Mr. Patton committed unless you can show me the specific reason that they would be relevant to this issue. And right now we're just having a general argument and you're just making a proffer, but that's what I haven't heard.
Well, I would reiterate the points that I just did. They're certainly relevant to how these bodies were disposed. They're relevant to who was killed and potentially why they were killed. There's evidence that Melissa knew about Carl Patton's murders, which is something he kept under tight
But
wraps.
again, that's the fact of the murders, you're talking about the circumstances.
It's a motive for the murders, and it would be a motive for this murder as well. That's evidence of third-party guilt. It's relevant.
Mr. McDermott, I think we're talking past each other.
Okay, I'm sorry.
I'm not saying that you're right now, as a baseline guidepost general proposition here, I'm not saying that I expect the defense is not going to talk about the fact that Carl Patton is a convicted murderer. And I'm not saying that you're not going to cross-examine Ms. Patton about her involvement and that sort of thing. I'm also not saying that the fact that he's a convicted murderer might have some relevance to this case and whether Melissa had motive, or whether that might have formed some motive for Mr. Patton to be this alternate theory of the crime murderer, right? That's not what I'm saying. What I'm saying is I understand Mr. Fawcett's argument to be, it sounds like you want to go in and let's have a little mini trial about the circumstances of each of those murders. And that's what I'm trying to figure out. Why would anything other than the fact that he committed murder, right? Even the numbers, even the names, but why would the individual circumstances of those offenses, other than potentially some leeway to cross-examine Ms. Patton, Norma Patton, why would that be relevant?
Well, can the court help me out here? Mm-hmm. When you say, oh, I lost my point, I'm sorry.
Sorry.
In the last thing you said, obviously we would agree that the fact that he committed murder is relevant. But you're saying what more than that is relevant? You're asking me what beyond that would be relevant in this case. And I think anything that okay, let me go back to the point. You're saying we don't want to relitigate this case. And you hear me trying to relitigate the Flint River.
Yes.
What part about me reciting the facts that are on court records in a guilty plea hearing, what part of that is relitigation? These are just facts about how those murders happened, what their motives were, who they killed. Those are facts on record, testified to under oath. There's no litigation happening. But those are facts on record that are relevant to the facts that'll come out in this case. And that is directly relevant to third-party guilt.
Okay. So, Mr. Fawcett, as I understand the state's motion, it was an effort to limit the nature and scope of evidence that will come in about Mr. Patton. Is that a fair general characterization?
Absolutely, Judge, that's correct.
Okay. So,
and let me just say this, if I may.
Sure.
I sometimes can miss things, but I don't know that we've received the transcripts that are being referred to by counsel.
Well, that's a different issue. Well, and when and if that arises, because I can't deal with all of these issues in a vacuum in the abstract, right? Some of these are going to have to come up in the moment, and that's fine. What I'm trying to do, which I think is the purpose of motions in limine, is to give the party some general guidance about what's okay and what's not. And I think that Mr. Carl Patton's existence history and affect, the fact that he was even briefly a suspect, the fact that Ms. Patton was allegedly involved in his murders or in cleanup, whatever, right? Those things are fair game, and I think that that to the extent the defense, I think those things are going to be facially relevant and not overly prejudicial. What I am concerned about, though, is confusion of the issues and prejudice that might arise if we go too far into the granular details, absent a clear showing of specific relevance of those details into the details of the killings committed by Carl Patton. And so that's my general guidance to you, understanding that as we start asking questions and get into the back and forth of actual witness presentation, you may satisfy me that it's necessary for you to go into the particulars of one or more of the particular killings by Mr. Patton. But right now, in a vacuum, absent a particular showing, a more particularized showing of relevance, I'm saying stay up here at the 50,000-foot level and let's not get down into the weeds unless and until there's a showing that it's relevant for your purposes in this case.
So, just to be clear, what I've already mentioned about the motives, at least in two of those killings, to keep people silent who were going to talk about his murders, is that 50,000-foot level, or is that down in granular level, or where are we talking about? Because a general motive for killing somebody seems to me would be directly relevant to this case.
So I think you're asking me to conduct a sort of quasi 404B analysis, right? In terms of, I understand Mr. Carl Patton doesn't have any 404B rights in this trial, but
also that's been specifically talked about in the case law.
I understand.
404 does not enter into the analysis at all.
I understand. I guess my point here is I've given you, I think, what are the general broad strokes, and so beyond that, I think you need to conduct your examinations of your witnesses in the way that you believe is necessary, and I will deal with individual objections as they arise. Again, my point is Mr. Patton's crimes, that they happened, that he was convicted for them, that Ms. Patton was involved in them, I think those are all, we're all expecting those are going to be relevant and discussed in this trial. I'm just trying to avoid getting down into the nitty-gritty of it unless it's relevant and necessary for you, and if that's the showing that you're going to try and make, then I may agree with you. I'm just not going to do it right now.
Okay.
Okay? Anything else that we need to take up pre-trial?
Last thing, Your Honor. Good morning.
Good morning.
I know that there may be some witnesses that have criminal histories. I believe some may be older than 10 years. It is my understanding that we have not received any notice from the defense if they're going to try to impeach using convictions older than 10 years. And so I just wanted to bring that issue before the court, because I don't know if they exist or not, or if they plan to, but there needed to be notice if that was going to happen. And so wanted to kind of deal with that before a question comes out on the stand, and we haven't addressed it, Your Honor.
Mr. McDermott?
Off the top of my head, I can only think of one that might be in that category, and in 1991, and it's not an impeachment issue, it's another third-party guilt. It's actually to explain one of the reasons Melissa ran away from home. And in 1991, her sister had a baby in their house. I don't know if it was unexpected. Certainly it could have been unexpected, but she did it in secret. She didn't want to keep the baby or something of that nature, and tried to secretly dispose of that baby in a clothes hamper in their house. And we have the court records from that conviction. I'll finish the story briefly. Melissa is the one who found that baby, and she didn't know what to do with it. She ends up telling people at school, and then the police come. Long story short, Tina ends up getting convicted for concealing the death of another in 1992. I don't even really need to talk about the conviction aspect of it. I just need to talk about the crime and what happened to Melissa. And, you know, it was shortly after that 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 was the final straw for her. She starts running away from home regularly. So I do want to talk about that incident if it's going to be an issue with the conviction or whatever. I'm not bringing it in for impeachment purposes.
Okay. So two things. One, I agree generally with Mr. McDermott's characterization that everything that all the circumstances that led up to whatever conviction occurred might be relevant with particular witnesses or whatever, and the fact of the conviction, it sounds like, is not really his target. Although I agree with the state that if you wanted to talk about that conviction, then I think there are some notice obligations. That's number one. Number two, though, is setting aside the notice obligations from a substantive perspective. The purpose of the rule prohibiting convictions older than 10 years is because presumably they're stale. They're not particularly compelling or relevant to the veracity of a witness who's testifying now. But if we're talking about events that occurred more than 20 years ago, right, then the fact that they were convicted of something 22 years ago might be more relevant than it normally would if we're talking about a crime that happened last year and somebody wants to try and impeach or bring in evidence of a prior conviction from 10 or 15 years ago. And so that's my only concern. Ms. Hilton.
I understand that, and I guess this particular incident, what I think the state is having an issue with is the relevancy of Ms. Tina Patton having a child and Melissa.
So forgive me, Ms. Hilton, for interrupting you. I'm not ruling that that information is admissible. What I'm saying is that Mr. McDermott is not, to my ear, indicating that he intends to offer evidence of a conviction of that witness, which means there would be no notice obligation, number one. And number two, the issue about the substance of what he wants to offer, that I'm going to have to deal with that when it comes up. I don't know what the relevance is yet because I don't know why he would offer it. He seems to think that he has some facial basis to make a showing of relevance at the appropriate time.
Thank you, Your Honor. I definitely understand the notice requirement if that's his understanding. My concern now, hearing what he may offer it for once the witness is on the stand, is that we can't unring the bell once he asks whatever question he asks in a moment for me to object. If he asks, did you kill your baby and leave the baby at home, and then I object, that question is already out and for. So if he's going to use, I want to deal with it maybe in a motion in limine, that's not relevant. But I'm not fully understanding all of the facts that he would like to bring in, since I'm just hearing about it now.
Mr. McDermott, why is it that you believe, I assume that you're going to go into, you plan to go into that when Tina Patton is on the stand?
I intend to mention it in opening, actually, Your Honor, because one of the key issues running through this trial is Norma Patton's claim that she had a loving relationship with Melissa. And we're going to put up lots of evidence that that was not the case. That Melissa wanted to come back home and Christopher wouldn't let her. That Melissa kept trying to leave Chris and come back home to them, and it's just simply not true. And we have tons of reasons why. And one of the reasons why that led to her initially starting to run away is the discovery of this baby, and that was the last straw. And I think it's going to be a testament to the abusive and foul relationship she had with the people in that home and her opinion of them. And that's all relevant to why she did not have the relationship that Norma Patton is going to claim on the stand that she did have.
Ms. Hilton?
Your Honor, because Ms. Wolfenbarger isn't here, some of this would be speculation on the part of anyone to say this is the reason why she left home. So we don't even have credible, I believe, evidence as to this is going to be the reason why she went home, or one of the many reasons why she went home. So now we're on a fishing expedition to ask questions that are speculative in nature, as well as not relevant in this particular instance as to whether or not Mr. Wolfenbarger killed or murdered his wife. I think we're now going to essentially try to muddy the waters in this trial to put in all of this extraneous evidence, and it's taking away from whether or not Mr. Wolfenbarger killed his wife. And so this particular evidence of a baby being killed in a home, or potentially being killed in a home, and this is the reason why she's running away, is speculation. I don't know who's going to testify to that. So when you start asking those questions, now you are bringing in issues that are confusing the jury without any clear evidence to that, Your Honor. So that is our position as to why the details of this particular incident is not relevant, Your Honor, in this case. It'll be speculative and it's not relevant.
Okay. I agree with you if the defense tries to argue or to get a witness to say, isn't that why Melissa ran away or whatever, that's argument, right? But if Mr. McDermott can establish facts that created what he's going to argue was a hostile home environment that would not lend itself either to indict the credibility of those witnesses or to demonstrate why Melissa wasn't there, I think that's fair game. But again, I would like to caution that there is a risk here of confusing the jury, of inflaming the jury with things that are extraneous, and we're all going to be very cautious about engaging in that endeavor.
Thank you, Your Honor.
Okay. Anything else?
Nothing, but I just emailed Ms. German for the Zoom link. I did intend on using PowerPoint going on.
Okay. Ms. Johnson, if you can hear me, or Ms. German, if you could make sure that the lawyers have the Zoom link for today so they can log in. Last thing, Mr. McDermott, anything else you need the court to address pre-trial?
No, ma'am.
Okay. Okay, so the last thing that I needed to take up, I do have all of my jurors. I did want to let you know that juror number, no, not that one, the dialysis. (43), who y'all will recall is the gentleman that that told us that he was on home dialysis. He has presented today, he is here, But he has also sent to my office a letter from a physician at Dialysis Care Center asking for that individual to be excused because he has a diagnosis of end-stage renal disease. My understanding is, I think the numbers indicate that he is an alternate, but he is here. I think there was a discussion on the record when we were talking about whether or not to excuse that juror for hardship that I think I and the lawyers asked him any number of questions about whether he could make it work, and it seems like maybe he doesn't think he can, but he didn't say that clearly during the process of voir dire. What are our thoughts on what to do with that? Now, I feel like if he's here, I need to inquire, is he asking to be excused, right? Because this letter, since he didn't say that, number one. Number two is, if it's a matter of accommodating him from a time perspective, right, I can say, hey, well, I'll guarantee you we'll be out of here every day at 5 o'clock, or whatever I might need to do to enable him to conduct his home dialysis timely. What are your thoughts, gentlemen?
I would agree with that, yeah.
I agree.
Okay. With your permission, I'm going to have, rather than bring him out here to ask that question, I'm going to have my staff ask, are you aware we've received this letter? Because this letter was faxed directly to us from the healthcare provider.
I was not aware.
I'm sorry?
No, go ahead, Thomas.
And I'm going to have Ms. Sherman ask him, are you asking to be excused? So that I can then make that clear to y'all, and then y'all can make a decision about whether we wish to excuse him or not. Everybody good with that, Mr. Fossett?
Yes, as long as the defense is.
Mr. McDermott?
I'm good with that.
Okay. Ms. Sherman, come here, please. Anything else while I wait for that answer? Okay.
So if we excuse him, or are we considering getting another alternate? Or we haven't got to that stage yet?
Well, he is an alternate, so I mean, we would just proceed with only one alternate.
That was the question.
Yes, sir.
Proceed with one, or go ahead and try to find another.
That's y'all's decision. I'll do whichever you ask. Logistically, seating another alternate at this point and getting them here from whatever corner of the county they reside in might mean that we're starting opening statements at 1 or 2 o'clock instead of at 11. I'm told that he seems quite comfortable back there. That was one of the reasons I wanted to ask if we can accommodate you to make it easier. Are you asking to be excused, or did you just want us to be aware of this medical information? So I don't know that y'all can think about what your options might be if he says he wishes to be excused, but I don't know that we have to solve that problem just now, because he might say he's fine. He'll take it day by day. I'm sorry, Ms. Cantrell, not on the record. The Zoom link that you So, with y'all's permission, Ms. German did inquire with juror number 43 whether or not he was asking to be excused or whether, you know, what the purpose of providing us with that information was. And he has communicated to her that he wanted us to be aware of the nature of it, that he reached out to his doctor, but that he's actually not asking to be excused. And so he has stayed and elected to remain. We did advise him that we would try to accommodate him to the extent necessary. And he mentioned a couple of things that we'll need to work with schedule, but nothing that I've seen that's too burdensome in terms of, you know, ending one day at about 3:30 or something like that. So, but we're going to go from there. So 43 stays. I just wanted you to be aware that I had that information from his doctor. Anything to put on the record regarding that matter, Mr. Fawcett from the state?
Not from the state, Judge.
Mr. McDermott?
Nothing from the defense.
Okay. So are we ready to get started? State ready?
Yes, I'm going to share my screen now with the court
Okay.
commission.
And have the parties had a chance to make sure that there's not anything significantly objectionable that, I mean, like, have you shown each other? I don't want to.
I did show counsel what
Okay.
I intended to show in the opening statement. I did not hear an objection.
Mr. McDermott?
I don't believe I got your full PowerPoint presentation, did I?
It sent to you, but okay.
So I have not been able to look at that, right?
Well, I showed you the photo.
Well, let me say this. I'm going to, excuse me, gentlemen, I'm going to be talking to the jury for about the next 25 minutes, so I think you'll have time to look at it, and then you can let me know if there's an issue. Okay?
Oh, that was it. I showed you.
So as far as the content, you're not.
No, I'm not showing anything else.
Your share screen works. If you'll take that down, please, while I talk to the jury.
Absolutely. Thank you.
We're ready for the jurors. You all please be seated. Good morning, ladies and gentlemen. Good morning. Thank you all so much for your patience this morning as we get through some of our processes that need to happen. I'm going to talk to you a little bit more about how this process will go and give you as much guidance as I can before we get started today. But first, counsel, is this your jury?
Yes, it is, Judge Winston.
Yes, Your Honor.
Thank you. So, ladies and gentlemen, now that I've told you you could have a seat, if you'll please rise and raise your right hand. Members of the jury, Do you swear that you shall well and truly try the issue formed upon this bill of indictment between the state of Georgia and Christopher Wolfenbarger, who is charged with murder and felony murder? A true verdict give according to the evidence, so help you God. Please say yes if you agree. Yes. Thank you all. Please be seated. So, ladies and gentlemen, thank you all again for your patience. Sometimes things move a little bit slowly, and I promise you that we are trying to be efficient and cautious of the importance of your time and attention throughout this. So, ladies and gentlemen, we are now ready to begin the trial of this case, and I have some preliminary matters that I want to discuss with you. You'll see me reading a good bit, and that's because there are lots of places where it's good that the judge doesn't ad-lib, right? And so I'm going to read some things to you to make sure that you understand what your obligations are and to provide you as much information as I can as we get started. So I've already told you about our deputies. They're an excellent resource for you in terms of asking questions about what the schedule is going to be, where and when you can go or not go. I'm going to try and give you some instruction about that as well. From this point forward, as you just came into the courtroom, you will only enter the courtroom through this door and only when accompanied by a deputy. So that means that when we need you to leave, the deputy will come and open the door for you and hold it while you go out. And when it's time for you to come in, the deputy will come in and announce your arrival. The deputies can also tell you a bit about our fairly meager offerings for lunch. I encourage you to consider bringing your lunch. We do have some options, but not a whole lot, and sometimes you'll be pressed for time, and I want to make sure that you do have an opportunity to eat and to make sure that you don't get hungry or distracted while you're serving as a juror. So I think all of you are wearing your juror stickers. If you would, make sure that you're always wearing those when you're in the courthouse. And that is for a very important reason. So from now going forward, the people in this courtroom, the witnesses in the case, the parties in the case, they're not allowed to have any contact with you outside of this courtroom while we are engaged in the trial. And so the reason that I ask you to wear those stickers is so that you can be identified as a juror should you encounter someone in the hallway. Now, if that happens, don't panic, just let us know, right? Now, what may very well happen is you may encounter a witness or a lawyer or a party while you are waiting on an elevator. If they go away from you, please don't be offended, right? They're not being rude to you. They're simply trying to satisfy the court's obligation and their legal obligation that they not have any contact with the jurors outside of this proceeding. So we will generally hold court from 9:30 to 5:30. I will tell you each day when we adjourn when you have to come back and what time you need to be back. And I will try to be very cognizant of taking breaks in the morning, taking lunch breaks, things like that, so that y'all will have a chance to have a break from what is the real, mental focus of being here in the courtroom. So, ladies and gentlemen, you have been sworn and impaneled, and you are about to try a criminal case entitled The State of Georgia versus Christopher Wolfenbarger. Before we begin the trial, I'm going to give you some preliminary instructions on the fundamental principles of criminal law, and I'm going to instruct you on the role of the judge, the role of the jury, and the lawyers, and give you an overview of trial procedure. Many of you may have never served on a jury before, and it is therefore necessary that these instructions be given so that you have a general understanding of the procedure in a criminal trial, of what will be expected of you, and how you are to conduct yourself during the trial. The defendant in this case is charged in the indictment with crimes that are violations of certain laws of the state of Georgia. Now, I want to emphasize to you that the indictment, including all of the counts in it, and the plea of not guilty, are the legal procedures by which these criminal charges are brought against the defendant. The charges and the plea of not guilty are not evidence of guilt, and you may not consider them as evidence or implication of guilt of any crime whatsoever. This defendant is presumed innocent until and unless he is proven guilty. This defendant enters upon the trial of the case with a presumption of innocence in his favor, and this presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the crime or crimes charged. Now, under our system, it is my duty as the trial judge to determine the law that applies to this case and to instruct you, the jury, on the specific rules of law that you must apply to the facts in arriving at your verdict. Now, I'm giving you some of those instructions now, and I will give you more detailed legal instructions after the evidence has been presented and the lawyers have made their closing arguments. Now, during the trial, I may be called upon to rule on motions or objections to evidence. Nothing I say in making those rulings or at any time during the trial is evidence that I have any leaning in the case whatsoever. My only interest in this case is to see that it is fairly tried according to the laws and the Constitution of the state of Georgia and the Constitution of the United States. Now, as expected, these lawyers serve as advocates for their clients, and they are duty-bound to represent their clients to the best of their ability. The lawyers also serve as officers of the court, and as such are bound to follow applicable laws, trial procedure, and the rules of evidence during the trial. Now, if at any time the lawyers believe that any law, procedure, or rule of evidence is being violated, they're allowed to make motions regarding the conduct of the trial or objections to the admission of evidence. In making these motions or objections, the lawyers are simply seeking to fulfill their duty to their clients and to the court. Now, sometimes those motions may need to be heard outside the presence of the jury, and one of two things will happen. Sometimes you'll see us come over here, as I think you saw us do during voir dire, and we'll engage in a quiet conversation if it can be done quickly, and that's to minimize the number of times we might need you to leave the room. But sometimes those things require us to give it a little bit more time, and so we will have to excuse you to the jury room when we need to do that, and we will just thank you in advance for your patience and understanding that those matters are important when they are occurring. We will try to keep them to a minimum, and again, to be cognizant of the importance of your time. Ladies and gentlemen, trial procedure in a criminal trial is generally as follows. First, the attorneys for both sides have the opportunity to make what is called an opening statement. Now, both sides are entitled to make an opening statement, but neither side is required to make an opening statement. Remember that what the lawyers say is not evidence, but it is a preview or an outline of what they expect the evidence in the case to be. Following the opening statements, the evidence will be presented. Evidence can be presented in the form of testimony that you will hear from witnesses who will take the stand, or physical evidence that will be labeled with exhibit numbers for identification. After the presentation of all the evidence, the attorneys will have the opportunity to make what is called a closing argument. Now, at this time, the attorneys may suggest to you which laws are applicable and how they should be considered in light of the evidence, and point out to you certain parts of the evidence that they think are favorable to their position. The goal of a closing argument is to persuade you to decide the case in their favor. Following the closing arguments, I will charge you more specifically on the law that applies to the case, and I will then ask you to retire to the jury room to deliberate and reach your verdict. The jury has a very important role. It is your duty to determine the facts of the case and to apply the law to those facts. I will instruct you on the laws that apply to this case, but you must determine the facts from the evidence. Evidence, by definition, is the means by which any fact in issue is established or disproved. Evidence consists of two things, either testimony or exhibits. Testimony is the testimony you will hear under oath from those who take the witness stand. Exhibits are those documents, photographs, or physical evidence that are admitted into evidence. Ladies and gentlemen, the object of this trial is to discover truth. And during the trial, the admission of the evidence will be governed by certain rules of evidence. Those rules were drafted with one prominent purpose in mind, and that purpose is the discovery of truth. Now, consequently, the rules of evidence seek to assure that only the best and highest evidence is admitted for your consideration. During the trial, the attorneys have a right to object to the admission of evidence if they believe that its admission would violate a rule of evidence. I will admit or exclude the evidence according to those rules. If I overrule an objection, that means that you are allowed to consider the evidence that is being offered. On the other hand, if I sustain an objection, that means that you may not consider the evidence that is being offered. Now, you should consider only that testimony and only those exhibits that are admitted, and you should draw no inferences and make no assumptions about the evidence objected to if the objection was sustained. Now, sometimes you might see or hear inadmissible evidence before an objection is asserted or before the court can rule on the objection. If that occurs, I may instruct you to disregard that evidence. And if you are so instructed, it is your duty to disregard that evidence in its entirety during your deliberations. You, the jury, must determine the credibility and believability of witnesses. It is for you to determine which witness or witnesses you will believe and which witness or witnesses you will not believe, if there are any that you do not believe. In determining the credibility or believability of witnesses, you may consider all of the facts and circumstances of the case, the manner in which the witnesses testify, their interest or lack of interest in the case, their means and opportunity for knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, and the occurrences about which they testify. You may also consider their personal credibility as it appears to you from the witness stand. As the fact finder, it is your duty to believe the witnesses whom you think are most believable, and it is for you alone to determine what testimony you will believe and what testimony you will not believe. Ladies and gentlemen, it is important that you pay close attention to the evidence as it is being presented during the trial. And there are a couple of important reasons for that. Number one, there may be evidence that is admitted and presented to you to observe during the trial that you may not have with you during deliberation. And so it's important that you observe the evidence that is being presented to you when it is being presented during the trial. Also, as I mentioned a moment ago, observing witnesses as they testify is important. And so for that reason, I'm going to encourage you that if you at any time are unable to see or hear, or if you are suffering from some personal discomfort that distracts your attention, to raise your hand, let me know, and we will take a break or do what we can to address the issue with your being able to see the evidence or hear the evidence, or be comfortable enough to focus on the evidence as it is being presented. It is important that you view the evidence, ladies and gentlemen, with an open mind at all times, and that you reach no final conclusions until the trial is over. Do not jump to conclusions before all of the evidence is presented. Also, remember that during the course of the trial, it would be improper for you to discuss this case with anyone or to allow anyone to discuss the case with you or in your presence or hearing. This applies even to discussions amongst yourselves in the jury room or elsewhere before actual deliberations begin. I think you have been provided with notepads, so I want to take a moment to address the issue of note-taking. You are allowed to take notes, but you are not required to take notes. If you decide to take notes, please remember not to let note-taking distract you from observing the evidence in the courtroom as it is being presented. Your observations, as I said a moment ago, of the witnesses during their testimony can be vital to your determination of their believability, and the notes that you take might refresh your memory when you are called upon to deliberate. But importantly, the notes that you take are only to refresh your recollection. They are not evidence. They are only for you to recall the evidence as it was presented at trial. They are memory aids. It is the duty of each juror to recall the evidence, and while you may consider another juror's notes to refresh your recollection of the proceeding, do not rely on or be influenced by the notes of other jurors unless their notes help you in determining your own independent recollection. Notes are not entitled to any greater weight than the recollection or impression of each juror as to what the evidence may have been. Now, that's the conclusion of the introductory instructions that I need to give you. Before I call on the state, I do want to make sure that everyone is aware that the rule of sequestration has been invoked. And if there is anyone in the courtroom who anticipates that they will be called a witness in this matter, I ask that you please exit the courtroom and do not re-enter until you are instructed to do so or called by one of the parties as a witness. I also will just mention again, as I've asked the attorneys, you know who your witnesses are better than I do, and so if you'll just keep an eye out in case they wander into the courtroom so that we can get them out of the courtroom as quickly as possible. And with that, I'll call upon the state. Does the state wish to make an opening statement?
We do, Judge.
Okay, you may proceed.
Thank you. morning. Good morning. This is the State of Georgia versus Christopher Wolfenbarger. It's been 27 years since 1998. And specifically, December of 1998. That was the last time that Melissa Wolfenbarger was ever heard from. At that point, in 1998, Melissa Wolfenbarger was 21 years of age. She was married, had 2 children, had a mother, sister, and after 1998, December, neither one of them ever received a phone call, not a visit, not a card. Not after Christmas of 1998. Not after her mother's birthday in 1999 in February. So you're going to hear that Melissa, at the age of 21, she had experiences when she was a child when she would run away from home. She had experiences during her adulthood after she married this defendant, Christopher Wolfenbarger, when she would not talk to her sister for a period of time. But she would always keep in touch with her mother. Most importantly, she never let a holiday go by without calling or visiting. In November of 1998, Melissa had the intent to visit her mother for Thanksgiving. They spoke. One of the things that Melissa was really looking forward to was getting a photograph of her pawpaw, her grandfather, the father of Carl Patton, Melissa's grandfather, and that is Carl Patton, Melissa's father. And that is the husband of Norma Patton. She wanted that photo. And Norma Patton expected that at some point between Thanksgiving, even though she didn't get an opportunity to go visit her mom, that she would get that photograph. Well, when Christmas came around, she was concerned when she didn't hear from her. But by the time she got to February, she knew something was wrong. Melissa never would let that much time go without talking to her mom, not especially during that period of time, not on her birthday. Well, it took some time for authorities to be alerted, because you're going to hear that Melissa wasn't reported missing until January of 2000. And that was because this defendant, Christopher Wolfenbarger, you're going to hear from his own words. You're going to hear what he told the detectives, what he told his children. He never looked for her. He never reported her missing. So when Norma Patton and Tina Patton are looking for Melissa, where is she? She's not working anymore. She worked at Waffle House. She's not showing up to her job. She's not looking after her children. She's not checking on her children. No word. Well, the authorities tell them that, well, Melissa is 21. She's married. She's got her own life. If she hasn't called you, then maybe she doesn't want to talk to you. Her husband hasn't reported her missing. And you hadn't talked to her in a month. Well, not really much for us to do right now. But eventually, Melissa's mother goes to Henry County, and they started an investigation. But even though they talked to friends and family, they even talked to Christopher. And all we get from him is she just left. That's it. That goes on for 3 years. She gets unidentified for 3 years. And that takes us to really when we locate the remains of Melissa Wolfenbarger. They were located on 2 different days. April 29th and June 3rd of 1999. Now, April 29th, George McKeitron is driving on the area and heard questions about Avon Avenue. That location is the location of Action's last company. You're going to hear that is the location where Christopher Wolfenbarger worked. Glass company, kind of a manufacturing plant. They have industrial equipment at this location. That's where he worked. Although they had no reason to think that that was anything significant at the time, because in April 29th of 1999, all they knew was that there was a head in the roadway, partially, fully, pretty much fully decomposed. And Mr. McKeitron George McKeitron is driving on in that area on Avon Avenue, and he sees something that he thinks is kind of odd. So he stops and looks at it, goes and gets his daughter, and comes back, and he can see what clearly is a human head. Now, something that he would tell you he couldn't believe with his own eyes, or what he couldn't believe. Well, that begins the discovery and really the process of trying to identify that skull. That's those same detective, the lead detective at that time was Dale Kelly. You're going to hear from the Fulton County medical examiners, investigators, Tina Miller. They were all out there at that location on Avon Avenue, April 29, 1999, collecting evidence, taking photographs, some of which you'll see. Ultimately, they start looking for information on who this could belong to. Then you find the extremities on June 3rd, 1999. As these extremities are found, everything but the torso, so everything but the midsection of Melissa Wolfenbarger is located. Fingers. And you'll hear from the detectives, you'll hear from the medical examiners. When the skull was found, it had a portion of the spine attached to the skull, and it appeared as though it had been severed or removed with some type of circular saw. The extremities were examined. Detectives, medical examiners, the anthropologists who worked for the Fulton County Medical Examiner's Office, they observed signs of tool marks. The anthropologist describes the different lines on the bones as what happens when a saw is attempting to catch a groove and actually make a cut. You'll see the bones where there's the saw marks on the finger of Melissa Wolfenbarger. You will see the end of the finger where it appears as though you see ridges on the bone where that saw cut. But even on June 3rd of 1999, they even had these cases connected. They were found about 50, 60 feet from each other in that same area. They didn't have a basis to connect to, so they were in the medical examiner's office as 2 separate case files. Skull found on Avon Avenue, and extremities found almost 2 months later on Avon Avenue. It's suspected that the cases may be connected, but they didn't have what you needed to actually combine and connect the cases and say that they were. homicide investigation. The first thing that law enforcement does, especially when there's evidence of foul play, as in this case, when you find out who the victim is, who the person is, you go look in their background. And what did they find when they looked at what Melissa's life was like when she was alive in 97, 98? Who was she talking with? Did she have conflict with them? Is she married? What was her marriage like? Were there instances of abuse in the marriage? Had her husband ever been charged with anything related to that abuse, like hitting her? They looked at that information, and I'll tell you that at the time they did find the identity and were able to determine the identity of skull and extremities, Christopher Wolfenbarger was the primary suspect. I'll just tell you that. He was the person, the main person that they were looking at. He wasn't the only person, because you got to conduct a thorough sifting investigation, but they had evidence that Christopher and Melissa were involved in a tumultuous relationship, that Christopher was abusive, that he had struck her on multiple occasions. They had evidence that he had caused a black eye, that she had witnesses that observed bruises on her neck. They had evidence that at some point Melissa applied for a protective order to prevent contact with this defendant. You're also going to hear that on the day that Christopher was ordered to come to court, March 29th, ordered to come to court on July 29th of 1998, you're going to see that same day, Melissa appeared and requested for that case to be dismissed. Roughly 7-8 days after she was hit, 7 days after she went personally and applied for a protective order, 7 days after that, she goes back down to the courthouse and asks for it to be dismissed. I don't want to prosecute her. You're going to hear from a lot of witnesses in this case. You're also going to hear from a domestic violence expert. And that domestic violence expert will be able to explain that that is not uncommon at all. The victims of domestic violence to come back and say, I don't want to prosecute. You're going to hear about some of the reasons why that can happen. And that was the 21st of July, 1998. Officer Marlon Sutton responded to the residents at 824 Brookline Street in Atlanta. That was marital residence of Christopher and Melissa Wolfenbarger, the family owned home of the Wolfenbarger family that Christopher and Melissa were staying in at the time. When Marlon Sutton arrived at that location, it was a response to a domestic violence incident. And when he arrived, he got an opportunity to view Melissa Wolfenbarger and see her in person. What he observed was someone that had bruises, someone that had been attacked, someone that was hysterical and afraid. He didn't see Christopher there that day, though. He wasn't there, he left. So she was instructed to do as she did. You don't feel safe, go and apply for a protective order, which is what she did very much there. You want to see those documents you last week. The day after this, she goes down and applies for that protective order. By the time this case comes up, on March 1999, you'll see this document, in particular, state court documents, actually filing the formal charge of battery against this defendant, 1998. By the time it comes to the court, they can't find Melissa. Can't find her in March 1999. No way of knowing a month and a half later, her head was found in front of his job. And I'm going to say this too. Less than a minute drive from his house in walking distance. You and you got the location of Avon Avenue itself. So this is the Action Glass Company location right here. So this is where Christopher Wolfenbarger worked. You'll see this map, and witnesses will explain. Witnesses that were at this location in April of '99 when her head was located. You'll see on the photographs there will be a sewer here, and you'll see where her head is located here. Within about 120 feet from this job. And then in June, you'll see where the extremities, the sawed-off legs of Melissa Wolfenbarger are found in this area. The detectives will tell you when they examined the location, it appeared as though they saw an animal carrying a bag right where the head was located, from this area out onto Avon Avenue. So when they were able to make the connection, they come back with cadaver dogs, and they go back and look in this area, and that's how they find the extremities. That's how they find the June 3rd, 1999 legs, remaining parts that we found. We never found her torso, but the remaining parts we found was off. It'll give you a perspective of where his job is and where Brookline Street is. This is Action Glass. This is the junkyard where the extremities were found. Here is the location of the sewer where her head was found. And less than a minute drive is Brookline Street where Melissa and Christopher Wolfenbarger reside. Now, in 1999, you don't have the Atlanta Beltline. You don't have these buildings. This area is primarily wooded. But that is the location and the proximity of Christopher Wolfenbarger's job to where his wife's head was found, to where his wife's legs were found, and where they lived. This is a case about domestic violence. In addition to the evidence of the physical bruises on the person of Melissa Wolfenbarger, you're going to hear from her family. Her mother knew about the July 1998 attack. Melissa told her about it. She told her mother how Christopher was upset, wanted her to come back, and how he struck her in the face, how he grabbed her and dragged her by the hair. Her wife was arrested. Her mother was one of the persons that she told about that July incident. You're also going to hear from her sister, Tina Patton, who occasionally worked. Well, one time in particular in 1998, there was a 2 or 3 month period where Tina Patton, Melissa's sister, worked at a Waffle House. I believe it was Virginia Avenue Waffle House. They worked at a few Waffle Houses that year. Melissa didn't in particular. But during that period, in the early part of 1998, Melissa and Tina Patton worked at the Waffle House. And she would tell you that there was one day that she observed while she was working with Melissa during that period, she observed marks on the neck of Melissa, around the sides, and she knew immediately it looked, and she'll tell you this, it looked like someone had choked Melissa. And Melissa told her that the defendant, Christopher Wolfenbarger. And you're going to hear from a man that Melissa would have seen right when she died. You're going to hear that Melissa planned on leaving his defendant. You're going to hear from his own mouth that they weren't on good terms when she left, when she went missing. Thomas Dixon was also working at a Waffle House when he met Melissa Wolfenbarger. And towards the end of 1998, they started seeing each other. And at one point, Melissa was staying in a lodge or hotel with Thomas Dixon. And he'll tell you that he was fully aware that she was with this defendant, Christopher Wolfenbarger, but he'll tell you that she wanted to leave. And then during that week, she was staying with him. She fully planned on doing that, but decided to go back to him, to Christopher in particular, to see her children. She missed him. And Thomas Dixon will tell you that the last time he saw Melissa Wolfenbarger, Christopher Wolfenbarger came up to that Waffle House. Melissa and Christopher had a talk, and Melissa got hysterical. She started crying. Thomas Dixon will tell you that he went outside to talk to Christopher and told him that he has to leave until 9 o'clock when she gets off. You're going to hear Thomas Dixon tell you that when Christopher left, he peeled out in his Volkswagen, and that was the last time he saw Melissa. He'll tell you that she never came back to work at Waffle House. She never called. She never texted. And that is the evidence to show that that's consistent with what you'll hear from her mother and sister regarding the last time anyone ever saw her. And as I said, she goes unidentified for 3 years. During this period, the medical examiner that is working in Fulton County is also working in Twiggs County, and is first attempting to determine if a headless corpse that they located in Twiggs County could potentially be connected with this skull they find in Avon Road in Atlanta. That was one thing they were looking into. There were several missing persons in and around the state of Georgia that they were attempting to get dental records for and prepare. There were tooth extractions that were done during this period, but all in the attempts to find the identity of the person who that skull belonged to. There were attempts to conduct reconstruction. And what further confused it is the anthropologist plots skull dimensions on a scale, and you get a range. And sometimes those ranges overlap. So at some point, they'll tell you that her skull looked like it had been run over, damaged, and she, at some point, the anthropologist thought she could have been the skull of a male. All this was going on during this period from 1999, April, when they located the skull, June, when they located the extremities. All this is happening during this period, trying to find out who these remains belong to. And ultimately, Melissa doesn't get identified until 2003. And what triggered the identification ultimately is the arrest of Melissa Wolfenbarger's father. You're going to hear that Melissa Wolfenbarger's father essentially pled guilty to committing murder himself, committing multiple murders himself. And when he was arrested, it was a notorious publication, it was a notorious arrest. It garnered a lot of attention. You're going to hear that Carl Patton asked the lead detective when he was arrested, after he confessed, he asked the detective, told him that his daughter was missing for 3 years, he had no leads. He asked if he could find his daughter. Well, back to the Fulton County Medical Examiner's Office, we had this unidentified skull that they found 3 years ago. And with Carl Patton's statement, they obtained the dental records from Melissa Wolfenbarger's dentist, William Grant. Got a pediatric practice in the 80s and 90s. He obtained Melissa's original records, x-rays, and they did Dr. Mary Beth Hopkins, forensic dentist, conducted the examiner's office, conducted an examination, looked at the x-rays, looked at the fillings, looked at the dimensions of the teeth, and was able to make a conclusive determination that the skull that was found in April 1999 was in fact the skull that belonged to Melissa Wolfenbarger, because the dental records matched the impressions that she took from the skull. It was a match. That's when all the location of the job, that's when all the location of the house, the location of the extremities, and the skull between the job, that's when all that comes in. And that's already a suspect. That's when they're really focusing on this. You know what he says? Same thing. She just left. Then he says, oh, well, I dropped off at the train station. You're going to hear those statements from him. And you're going to hear the detectives question him about those statements in that explanation. As I said, the skull was identified by Mary Beth Hopkins. There were two medical examiners during that period in 1998 when we first started, in 1999 when we first started their examinations. Dr. Carol Terry and Dr. Joseph Parker. Dr. Joseph Parker is no longer living, but you will hear from Dr. Carol Terry, who will tell you that she examined the extremities. She'll tell you that she examined the skull and that they appeared to have evidence of tool marks. And she'll tell you that her expert opinion is that Melissa Wolfenbarger was murdered. The circumstances of her lifestyle, how she was living, what was happening to her, the circumstances of her remains, the condition that they were found in, makes it highly likely that she was murdered. That's what she'll tell you. Tina Patton is the sister of Mrs. Wolfenbarger that you will hear from at some point today. Melissa told her that Chris was responsible for the bruises on her neck. You'll hear from Norma Patton, Melissa's mother. She was told about the battery in July of '98. Melissa told her mother that she wanted to leave this defendant. She told him that he was abusive. You'll hear from Thomas Dixon, Melissa was in. Probably one of the last persons that Melissa saw. You also has information that he's going to tell you about how abusive this defendant was from Melissa's own mouth. And you're going to hear from Christina Garrett. Christina Garrett is the daughter of Melissa Wolfenbarger and Christopher Wolfenbarger. And the one thing she'll tell you is that she recalls her mother. And one thing that kind of stood out is she just remembers her mother kind of disappearing one day. And she'll tell you that one of the oddest things that she cannot reconcile is almost immediately after Melissa just vanished, this defendant essentially just removes all of her stuff out of the house. You can see the pictures of the mother, belongings, things of that nature. She's gone. While she was growing up, she would constantly ask him, "Where's my mother?" And you would expect that you would have heard an answer at some point, some type of explanation, where she would tell you that he never answered her question. He never told her I looked for her. He never told her I ever reported her missing. Nothing. In fact, she would tell you that this defendant would tell her while he was growing up that he knows how to get rid of a body. He knows how to not get caught. He also told his daughter, and you will hear this from her mouth, that he had a place to go on the run if he needed to. Now, Christina Garrett, Christina Wolfenbarger, grew up in basically being cared for by Kathy Wolfenbarger. Christopher Wolfenbarger's biological mother. She lived in the house until she was able to leave when she became an adult. You're going to hear that when she left the house of grandmother, when she was able to get out on her own, that's when law enforcement gets that information from her, around 2015, 2017. That information about what he told her while she was growing up. You're going to hear from Dorothy Jones. Now, Dorothy Jones is a resident of that neighborhood at that around that 800 Brookline Road area, close to the Action Glass Company where Christopher Wolfenbarger worked, close to the location where Melissa Wolfenbarger's skull was located, close to the location where Melissa Wolfenbarger's remains were located. Dorothy Jones is familiar with that location, and essentially what she's going to tell you is she pretty much hung out with Christopher pretty much every day during that period. She remembers him. She remembers Melissa. She remembers seeing signs of Melissa being abused. She would tell you that she saw Melissa with the black eye herself. Like she had been punched in the eye. She's also going to tell you that she's heard them fighting at that house, glass breaking. Probably the most disturbing thing she's going to tell you is that she saw him every day for about a 10-year period. And just one day, Melissa was gone, never saw her again, and Chris was gone. And she said, not only gone, but just kind of left all this stuff. It's in here. You're going to hear about the signs of trauma. There are going to be some photographs that you'll see solely for the purpose of illustrating the tool marks, the mechanical device that was used to disconnect the limbs of Melissa Wolfenbarger. And most importantly, you'll hear this defendant's own statement. During that 1999 period, he told the officers that he was fired because the owners thought he stole a saw. He admits to borrowing it. He admits to using it to cut the top off his car. He never got the saw back. And you'll hear from the anthropologists, the detectives, the medical examiner, that there are signs that Melissa Wolfenbarger's remains have been solved. You also hear about the day he was arrested, 2024. And it did not go like a typical execution of a warrant for homicide, because it took quite a bit of time to locate this offender. In fact, they didn't locate him in the residence portion of the house. They located him in the side area to the garage that was situated for living space. They found him in a something that looks the evidence to show it has the appearance that it was created for the purpose of the house. That's what the evidence is going to show. After about 40 to 50 minutes, they get the dogs, and you just can't hide from the dogs, right? The dogs hit, come on out of there. You see, that's what you're going to hear. When he crawls out of there after an hour, and the evidence is going to show he knew exactly who was at his front door. It will be your determination, your decision as to why. Possibly for you, it will be clear why. It will be clear. They were there to finally arrest this defendant for the murder of his wife. Arrest this defendant for dismembering his wife. They were there to arrest him and hold him accountable for taking Melissa Wolfenbarger from her mother and sister, most importantly, her children. At the conclusion of this
Thank you. Mr. McDermott, does the defense wish to make an opening statement?
Yes, ma'am.
Okay, you may proceed.
We can all agree that Melissa Wolfenbarger did suffer a tragic death. And you haven't yet heard the extent of which she had suffered a tragic life. But the extent of her suffering in life and in death had nothing to do with Christopher Wolfenbarger. The state's story begins correctly. This is a case about a horrifying discovery of human remains that later became identified as Melissa Wolfenbarger's. But the evidence will show you over the next few days that the state's story has gaping holes in it. And that the state is going to ask you effectively to imagine in order to connect the dots between those gaping holes. To fill the gaps, if you will. What the state has declined to tell you in this case is far more important than what they have told you. And your job over the next few days is going to be to see those gaps, to refuse to imagine, and to demand proof of all the elements of the crime that is charged beyond a reasonable doubt. You're going to hear evidence, some of it from their own witnesses, that multiple other individuals could have had something to do with Melissa's death, starting with her own parents. You've heard mention already of the Flint River murders. Melissa's father, Carl Patton, committed a string of murders in the late 1970s. He was suspected of those murders for a long time. He was investigated, but they were not prosecuted and proved until 2003, 4 years after Melissa's disappearance and death. You'll be presented with evidence that Norma Patton, his wife, helped him directly commit at least 2 of those murders, to dispose of the bodies, to clean up the crime scenes, and to wrap up the bodies and dispose of them in ways that are somewhat similar to the way Melissa's remains were found. Carl, Melissa's father, died in prison last December. Melissa's father eventually confessed to killing 5 people. Some of those were for personal revenge. Some of those were contract killings for money. And at least 2 of those were murders of his own friends because they knew too much. All of the victims were either close friends or family members. In one case, Carl knew how to stage a crime scene. He turned what was a shooting to look like an accident of a car on train tracks.
Your Honor, I object to the defense's content of their opening statement. The statements made by counsel are just simply irrelevant to any issues that are presented during this trial.
As previously discussed, they're going to be relevant to third-party guilt and motive score.
I'm going to overrule the objection on relevance grounds. I am, however, going to request that you, in line with our earlier discussion pre-trial, limit some of the details unless and until that evidence is presented to the jury.
I will not get into any more granular detail than I have so far.
Thank you.
Satisfactory?
Yes, sir.
Melissa's mother in 2 of those murders was a co-defendant. She confessed to planning 2 cold-blooded murders, cleaning up the blood, bleaching the floor, etc. And the murders from which the name that comes to those murders is the Flint River murders, is because one of those bodies was dumped in the Flint River, the other in the Altmoultrie River. And the only reason Norma didn't go to prison like Carl did was because she got immunity to testify against him. And she'll be here to testify this week. The evidence will show that there is also a Patton family associate who also had very strong motives to kill Melissa. For trying to get him prosecuted for allegedly molesting her in the 90s, and also because his father later turned out, to his knowledge, was one of Carl's victims. And until he learned that, he was a family friend and hung out with the family. And that man's name is Eric Martin Jackson. You'll find out later that at some point Martin learned what Melissa's father had done to his father. And he goes and buys a series of burial plots at a cemetery in 1997, a year before Melissa goes missing, or maybe a year and a half. And he buys them in the very cemetery that Melissa is buried in today. And later, because later he sold those plots to her family. And there are others I'll touch on in just a minute. We expect Norma Patton to come here and testify that she had a loving relationship with Melissa, that Melissa loved her, communicated with her, stayed in touch with her, tried to get away from Christopher's control every chance she could get, so she could come back to Norma's home and see her. But the evidence is going to show that Melissa was actually abused by her mother in her own home for many years and started running away frequently. Her mother locked her in a room all day, every day, from roughly ages 7 to 12. The evidence will show that their home was so foul and dirty that Melissa acquired a foul smell in her clothes and hair that made the other kids at school bully her and tease her. You'll hear evidence from Melissa's next-door neighbor and childhood friend that she will detail the abuse that she endured in that house. Moreover, at some point before Melissa ran away, her sister Tina had a pregnancy in that house, delivered the baby in the house secretly, and tried to dispose of it secretly in a clothes hamper in the house. 13-year-old Melissa discovered that baby's corpse. She eventually told school officials, who later called the police, and it was at that point that Melissa began running away from her home regularly. Christopher, in fact, first met Melissa because she ran away from home. And through a mutual friend, they met at that mutual friend's house. Now, Christopher and Melissa eventually got married, and they did so fairly hurriedly. They were both 17 when they got married. They had 2 children, very young, in very close succession. When Melissa was still pregnant with her second child in 1996, she went to Christopher's mother, Kathy Wolfenbarger, who will testify that Melissa asked her if she would take custody of their children temporarily. And she did. When Melissa got in some legal trouble the next year in Gwinnett County and went on probation for theft, it was after that that they began to, I think that's when they moved up to Brookline in July of '98. Their children lived with Christopher's mother in Stockbridge and later in Locust Grove, Georgia. When Christopher and Melissa moved up to Brookline in 1998, the children did not go with them. Now, you've heard some talk about an incident that happened in July of 1998 when Melissa took out charges against Christopher. You also heard the state tell you that Melissa came back and dropped the request for that protective order. What they didn't tell you is the very next day, Melissa calls Kathy Wolfenbarger from the Henry County Superior Court and asks her to please come down and sign the papers to make her custody of those children permanent. To make Kathy's custody of Melissa's children permanent. And Melissa permanently relinquishes her parental rights to those children. reasons Melissa originally gave for giving her children over to Kathy Wolfenbarger. And she tells this to Kathy, and she tells this also to Christopher's sister independently, was that she did not want her parents to have anything to do with her children because they are bad people. After relinquishing her parental rights, Melissa quit working around that time at the Waffle House in East Point with her sister, and for some reason begins randomly working at a Waffle House clear up in Doraville. No one knows why she went up there. According to everyone, no one had any connections up there, friends or family or anything. But she goes up there and starts working. Melissa started spending more and more time in Doraville, days at a time, working double shifts, spending the night at someone's house, and then multiple days, and days turned into weeks, she would be gone from Christopher's house. And it was at that time that she had started seeing Thomas Michael Dixon, the state mentioned a while ago. We'll have a chance to cross-examine him. In October of that year, Melissa got arrested in Gwinnett County for violating her probation, and she spent 30 days in jail until early November. The terms of her probation required her to do community service. This was outstanding from 1997, still in effect. She was to do community service, she was to take GED classes, and she was to report regularly to her probation officer, and she had not done any of that. And so they arrested her, gave her 30 days in jail, and then released her back on the same terms of probation. Within 1 month, she is already violating her probation again. Although she was not rearrested at that time. So at this point in her life, Melissa was spending as much, if not more, time in Doraville as she was at Christopher's house. She only occasionally came back to see Christopher. She had her own job. She had her own money. She had her own circle of friends. She had her own freedom. She had no obligations to her children. And so when in December of 1998, she did not come home for several weeks or months, Christopher could safely assume she had decided to live her own life on her own terms, wherever she decided to live. Moreover, if Christopher had raised a stink about it at the time, Melissa was in violation of her probation. She would have been arrested. Melissa's mother, Norma, is expected to testify variously, as you've already heard, that when she didn't hear from Melissa at Christmas in 1998, that's when she knew something was wrong. Alternatively, however, she will testify that no, it was not until my birthday rolled around. That's when I knew something was wrong. She will tell multiple versions of this story. In one version of the story, well, let me back up. The evidence will show you that in multiple versions of the story, whichever version she tells, she never reports Melissa missing until 2000, January of 2000. If something was wrong in December of 98, something was wrong in February of 99 on her birthday, something is wrong a month later, a month later, a month later, her mother doesn't report it. She doesn't file a missing persons report until 2000. The human remains in this case, as you've heard, were found on Avon Avenue. It's an industrial area near the west end of Atlanta. The evidence will show that it just so happens Melissa's father, Carl Patton, was familiar with this area. He grew up in a childhood home on Main Street in College Park. It's just a few miles down the road. Further, the evidence will show that Norma and Carl actually went up to Brookline Street right after her birthday in February of 1999. Christopher's empty house at that time. They learned from a neighbor that Christopher had moved out sometime between Christmas and New Year's. They also learned that from that neighbor that Christopher worked at Action Glass down on Avon Avenue. So they drove down to Avon Avenue and talked to the people at Action Glass. And they learned that he had been let go there. Again, this is February 1999. Carl and Norma Patton knew where Chris worked and where he lived months before the head was found on Avon Avenue, right beside where he worked. The state is correct that Melissa's mother and sister are going to testify against Christopher. They're going to blame him. They're going to call him a domestic abuser. But there's a lot of context you don't know. Keep in mind, as we've already said, the evidence is going to show that Melissa only met Christopher when she ran away from home. The evidence is also going to show you that Norma Patton has consistently, out of her own mouth, stated that she absolutely hates Christopher. From the very first time she ever saw him, she hated him. She worked and did everything in her power possible to prevent Christopher from seeing Melissa. When he was 16, would not let them date, or tried to prevent them from dating. Tried to prevent Melissa from leaving the house. Tried to prevent them from getting married. She tried to force Melissa onto birth control so that she could not get pregnant. Melissa's older sister joined that opposition to Christopher as well. You'll hear admitted from her own mouth that she did not like Christopher. No one in her family liked Christopher. And that she tried everything she could perpetually to intervene in Christopher and Melissa's marriage to get Melissa to leave Chris. The evidence is going to show that any claims of abuse or bruises on Christopher's part only began to be generated after Melissa started working with Tina at Waffle House. And the evidence of claims of abuse only come from witnesses who came under the influence of Norma and Tina. Christopher and Melissa, as I said, had 2 children, Chrissy and Joey. Chrissy was born in August of 1995, Joey 11 months later. Again, the state is going to present testimony from Norma and Tina, who will say that Melissa would never under any circumstances have abandoned her children. She would not have just left and never kept contact with her children. Impossible. But we already know that, in fact, she did legally abandon them. And the evidence will show that she also practically abandoned them. As I said earlier, when Christopher and Melissa moved up to Brookline Street, the children didn't come with them. They stayed way back in Stockbridge. The children were raised by their grandmother, believing that she was their mother. In September of 1998, when Melissa started leaving for large portions of the time with her work friends and her new lover, Thomas Dixon, she rarely returned to Brookline Street, where Christopher was. She even less hardly ever went down to Stockbridge. You will hear testimony that she rarely visited her children during this time, and that she rarely ever even called them during this time. Whatever Melissa's own personal aspirations might have been in regard to her children, the one thing we do know is the evidence will show that she rarely ever contacted them, and all but forgot about them. You'll hear testimony from Christopher and Melissa's own daughter, who's now grown up, of course. Her name's Christina. Some call her Chrissy. She will testify as a state's witness. She will say that she remembers to the day when her mother disappeared and all the pictures and belongings were removed from the house. Again, the evidence will show that she didn't live in that house. She lived in Stockbridge. The evidence will show you that at that time, Chrissy was every bit of 3 years old. Moreover, Christopher and Melissa's children didn't live in that house, as I said. Chrissy will also tell you that years later, she remembers Christopher making these offhand comments about he knows how to get away with murder, and the key is to hide the body, or to put it under the foundation of a house that's being built so they'll concrete over it and no one will ever find it. And there are various versions of that story. Christopher's son, Joey, who's also now grown up, will also testify, and he will say he was in the room when such comments were made. And that Christopher was speaking in the context of the boasts that Carl Patton used to make, who was a known killer. We'll have evidence in this trial that early in their relationship, Carl hired Christopher to help him in the roofing business. Chris spent time around Carl and heard him say these things. Even Chrissy will admit that when Christopher made such comments, it was contextual within a discussion and had nothing to do with Melissa whatsoever. Chrissy will also admit that everything she knows about the case, she learned from Norma Patton. Remember what I said at the outset. The state's going to present little points of circumstantial evidence, and they're going to ask you to use your imagination to fill in the gaps. Here are some of the gaps I want you to pay attention to. The state will not present any evidence of a cause of death. The state will not present any evidence of a murder weapon. The evidence obviously will show that there were remains that were discovered and that there were marks on the bones. But those wounds are all post-mortem. The state will present you with no evidence of how she died. The state will present no evidence of when she died or where she died. The state will present you with no evidence of where she was dismembered or when or how she was dismembered. They won't present any evidence of how she was transported to the site in the condition that she was. The state will provide claims about a saw that went missing from Christopher's work, allegedly around the time that Christopher was there. No evidence will show, even though the state claims otherwise, that he stole a saw from there, or that he was terminated for that reason. Furthermore, there's no proof that the kind of tool that actually made the marks on these bones was a saw. If so, what kind of saw? We have no evidence of what type of saw it would have been. We've got no evidence that will show that markings are distinctive of this reciprocating saw that was taken versus the circular saw he mentioned when he started his story. Furthermore, your common sense will tell you that there are about a literal million saws in the state of Georgia. Anybody can access a saw. Anyone can access a wide variety of types of saws. You'll hear from investigators from the APD. They will admit that once Melissa's remains were identified, they searched Christopher and Melissa's house on Brookline Street. They searched every inch of the home, inside, outside, every room, basement. They sprayed the entire house with a reactive agent that discovers drops of blood. Not a single drop was found. They took paint samples from every room. Why? Because when Melissa's head was examined, there were chips of paint in her hair. There were synthetic fibers in her hair. And forensic evidence will show that. The fibers were in fact found to be consistent with some kind of a bath mat or even a carpet. Very broad category. When Melissa's remains were the paint samples of her remains did not match any of the paint samples from Christopher's house. There was no match of any fiber from Christopher's house. A pubic hair was found on Melissa's remains. Christopher willingly submitted his pubic hair samples. They didn't match. Head hair samples were found. Christopher submitted head hair samples. The head hair samples didn't match. The medical examiners in this case made DNA analysis of the head almost impossible because one of the medical examiners or anthropologists soaked it in bleach. But the technology still won out in the end. The plastic bags in which the remains have been kept were recently re-examined using the most powerful DNA testing available in modern times, detecting trace amounts of DNA. And sure enough, one of those bags returned a profile that was viable for testing against subjects. It said there were at least 5 human contributors touching this bag. 2 of them were male. Christopher submitted his DNA. It didn't match. So the state has some huge gaps it needs to fill. And here's how we anticipate that they're going to try to fill that gap. We expect the state will also call a witness who is somewhat of an expert in the area of domestic violence or abuse. Perhaps you think, well, there's no DNA, there's no fiber evidence, there's no trace evidence in the paint chips. The really important evidence must be in the domestic abuse. But just as with the DNA and the paint chips and the fiber, etc., the expert will offer no support for the prosecution's theory in this case, and here's why. She doesn't know anything about the case. She's never interviewed Chris. She's never read a single police report. She's never even talked to the DAs about the facts of this case. Instead, she's simply going to say that she is a domestic violence expert and tell you signs and symptoms of domestic violence. We anticipate that their testimony on those matters will do nothing to prove that Christopher Wolfenbarger is a cold-blooded murderer. She doesn't know anything about him. She knows nothing. And we will ask you when trial is over to reject that level of fake expert testimony. Another thing, the state's going to offer evidence to say Christopher was the last person to see Melissa alive. In December of 1998. You've already heard it. But other evidence is going to show that Melissa's sister, Tina, actually saw her the following spring. At that time, Christopher had already long moved out of the area. Although Carl Patton was serving 5 life sentences in prison throughout this whole period up until he died last December, that did not stop Norma Patton from firmly expecting he would be paroled at some point. And she began looking into his parole within about 12 years after his life sentence had been served, his first out of 4 or 5. And the law technically at the time allowed for someone serving a life sentence to be eligible for parole after 14 years of service in prison. The evidence is going to show you that Norma operated on the belief that the only reason Carl had not been paroled was because his son-in-law, Christopher, had not yet been arrested. She will state explicitly out of her own mouth in a police interview that she believed that as soon as Christopher would be locked up, her husband would be released to come home. And she worked tirelessly for years with the DAs, with the police, and with media campaigns to make sure that happened. Ironically, the evidence will show that the investigators spent hardly any time at all investigating these other potential suspects. No hair samples were taken from them, no DNA samples were taken from them, no pubic hair samples, no searches of their homes, no paint chip samples taken from their houses. No one took DNA samples for this reason from the sister or the accused molester in her home or the friend down the road or anyone else. The evidence will show at most that Melissa somehow died and that someone tried to dispose of parts of her body. The evidence will show that everything beyond that is speculation and imagination. The evidence, as I said, won't show you a cause of death, a weapon, an instrument of death, an incident that led to her death, who dismembered or transported or scattered her remains. There will not be proof beyond a reasonable doubt in this case. There's no DNA, there's no high-powered technology, there's no expert testimony, there's no fiber evidence, no surveillance, no snitches, no co-conspirators, no confession, no eyewitnesses. The evidence will show that the state expects you to fill in all those missing gaps with your imagination. There is no evidence of these charges in this case, and that's why we will ask you at the end of this case to return a verdict of not guilty.
Thank you. Ladies and gentlemen, it's about 12:15, and so we are going to break for lunch, and when we return, we'll begin the evidence presentation portion of the trial. So it is 12:12. We're going to call it 12:15 and break until 1:15 for you to get lunch. Jurors are excused if the deputy will please escort them out of the room.
All right, for the jury.
May be seated. Any matters we need to put on the record before we also adjourn for lunch?
Not from the state?
Not from the defense.
Okay. We are excused. If y'all, I don't know what the plan is for witness presentation, but I do we need to resolve the photographs issue when we return from lunch?
Yes, we did.
Okay. So that's, after I said, I apologize, after I said you're excused, I realized I actually need you guys to come back at 12. I'm sorry, at 1 instead of 1:15, so that we'll just have a few minutes to talk through those issues. Thank you all. We are in recess until 1. Okay, so, sorry I'm a little bit late. We're also missing a juror, so they've got a few minutes to get here, but, so I've had a chance to look, Madam Court Reporter, we're going to, ready to go on the record after we get Mr. Wolfenbarger. Thank you, sir.
You may have 2 days of witness. Let's see, listen.
Okay, we are back on the record after our lunch break. Mr. Wolfenbarger is present here in the courtroom. And the purpose of our gathering before the jury returns for the afternoon session was to discuss and see about resolving, giving y'all rulings on the photographs issue. So during lunch, I had an opportunity to review the email that Mr. Fawcett forwarded to me. That was an email from Mr. McDermott regarding his objections to certain photographs. I've also had a chance to review the flash drive that was provided to me, which was a PDF of the various photographs, most of which are not objected to. I think my understanding is that the state had attempted to limit the photographs to some extent, and that Mr. McDermott was accepted that many of them that are in the PDF would be admitted, and that the ones we have still pending as objections have been identified by Mr. McDermott specifically by number. And so I'd like to just sort of take them up in turn, and understanding that the baseline here is these are gruesome photos because of the nature, the manner in which Ms. Wolfenbarger's body was disposed of, and that the manner in which the ME does its work and documents its work, that those things are necessarily gruesome and graphic. And so the question then becomes, are they relevant? And if they are relevant, are they overly prejudicial or for some other reason cumulative, et cetera? Mr. McDermott, if you want to start, I think your first one was photo number 35.
I'm trying to locate the file that has all
Sure,
we're talking about.
that's fine.
I seem to have lost the email. Oh, I remember. Now I have that in the folder. Give me just 1 minute, please.
Yes, sir.
Okay, and the number again, please?
35, which, so it seems to me, and correct me if I'm wrong, but it seems to me that at least the first few that you're objecting to, 35 through 51, 53, you might have additional objections, but it also seems as if your objection is to them in that clinical context, in the medical examiner's possession on like a white table, as opposed to, for example, Exhibit 16, which is also a photograph of the head that was recovered, but in the field as it was discovered.
Yeah, I just felt that I don't see what that adds. It's not necessary to complete any part of the medical examiner's testimony, and I think it's just cumulative in that sense.
Okay. As we move on to 39 through 42, which again, I think it's fair to describe as sort of various photographs of admittedly a body part that I actually can't recognize by what it looks like.
Which one, the first one?
39 through 42, I just have them labeled generally as body parts. One of them might be a leg, but I don't know what I'm looking at because I don't have that training, so.
So again, we have pictures of body, I think that exact body part in the field. We have a picture of the black bag just like that already in the field. I don't see what it adds to the medical examiner's testimony to show the same photograph in the same way, just on a different table instead of the ground. So I just think that's cumulative and unnecessary.
Okay, so I did look through all of the photographs, and although I did note there's a relatively close-up photograph of the head, Exhibit 16, in the field. I saw distant photographs and closer-up photographs. Maybe 21 is a closer-up photograph, but the rest of them seem to be in the field, seem to be in plastic bags, as opposed to the actual body part that was recovered from inside the plastic bag.
21.
Yeah, the 21, I agree with you, does appear to be one body part that was not housed in a bag, and the photograph is taken of it in the field, and it's a close-up. The rest of the photographs that I see in the field seem to either be not close-ups or of plastic bags. And correct me if I'm wrong, Mr. Fawcett or Mr. Wilson, but I assume that the state's evidence is going to be that these were recovered to the extent they were in plastic bags at the scene, enough to ensure there were body parts in it, and then it was the medical examiner's job to remove those bags?
That's correct, Judge.
Okay. And what about Mr. McDermott, 44 through 47?
Same objection.
And then 50, I don't even know what 50 is. Is it a tooth?
I believe that's, and this is from me talking to Dr. Terry, and
Yes,
she
sir.
wasn't even certain. But she thought it was like a top of the leg at the knee, and that's the cartilage between the knee joints, but maybe,
Okay.
maybe not.
Okay. This was maybe because I don't know what it is or didn't recognize it upon seeing it, probably the least offensive of the photographs that I saw.
Gory, it's almost like, rock collecting or something.
Right. But what is the nature of your objection to that particular one?
What does that do for the medical examiner's testimony? Because we're trying to get to the nature of the charges in this case.
Mm-hmm.
What does that lend to, relevant to her testimony toward those charges? I don't see any necessity. So we've got just one more body part, it's random, doesn't really apply to anything. We don't even know what it is.
And she wasn't even sure. What we talking
I'm fine with removing that one, Judge.
Okay. We will remove 50. Okay. And then we move on to 51, which seems to be a collection of the various body parts. Is this after cleaning or before?
I think that was before cleaning. I think that is before, Judge.
Okay.
Oh, well, clearly some of the bones have been stripped of any flesh that was on them. So I think you're looking at some of,
Well, that's why I asked the question. Do some of those bones, did they have flesh on them when they were collected? I don't know.
I'm not aware from any description of what was collected in the field and taken from the bags that they were just bones when they came out.
Okay.
So I think these are all, or at least the ones that are just bones here, have been stripped by the medical examiner.
Well, certainly, I don't know why the top portion of the leg, I don't know why that would be, why that wouldn't be stripped, and the ones at the bottom would. But I know that some of the testimony that I expect is that there was at least one animal that had gotten to the bag. There was the possibility of other animals, because the body parts were out in that wooded area for several months in And I would say in hot conditions, which one thing the doctors will say is they can't, because of the conditions and the variables, they can't say what rate of decomposition there was. And the other point I would say to that is there's going to be some manipulation of the remains so that the medical examiner can examine and look at potential damage. For instance, I don't find anything particularly gruesome about just looking at a bone itself, especially one that's been stripped of flesh, if that's what indeed happened. But the bone in the condition that it is in the photographs when they examine it allow them to see the damage to it. That's what allows them to see the appearance of assault, striking the bone. So for that reason alone, that visual image should be allowed to be displayed for the jury. It aids the testimony of the expert, and it allows for that expert to explain why they believe there are signs of assault on the bones of the respondent.
Okay. And then I have 53, 54, 57, and 59, which at least to my untrained eye, in the absence of evidence, seem to me to be an effort to document alleged saw marks, tool marks on the bones.
Yeah, and I was trying to make an effort to include at least one example of each one of those that's independent. But where they're double pictures of the same thing, I think it's cumulative and unnecessary. That's also why I think that, you know, we've got these close-ups where there are tool marks. That's why we don't need a whole table with the bones laid out. That you can't see any tool marks from that distance anyway. That's just cumulative and gory for no other reason. Doesn't document anything the medical examiner did except take the flesh off the bones. But, and maybe I missed one, that's fine, I'll hear about it, but as far as going through the list, I tried to include one example of each specimen that had tool marks that was unique. And I only object to the ones I thought was cumulative.
Okay.
Yeah.
Just one second, Mr. Fawcett, because I am going to let you respond. So to be clear, I didn't just limit my review to the numbers that Mr. McDermott mentioned, right? I was looking at them as, trying to take them as a whole with particular attention to the ones that you had asserted, looking for things like needless accumulation that would just be gory for no reason versus particular reasons. Again, without any context, I don't know if, for example, 53, 54, 55, 56, 57, 58 are different bones with saw marks in them or different angles of the same saw marks on the same bone.
I can't tell you with definitive accuracy, but my inclination was 54, 55 were the same, just different angles.
And Mr. Fawcett, the point of my asking that question is I believe that the presence of tool marks and the demonstration of them is relevant. Nobody's going to enjoy that process, but it's relevant and needs to be presented. If it is different bones, right, saw marks on multiple bones, I don't think that's cumulative. If it is, unless you anticipate that the medical examiner is going to say that there is a specific reason for two different photographs from, say, two different angles or something like that of saw marks on the same bone, then I would ask the state to endeavor to further limit the photographs. Yeah. So to Mr. That's okay, sorry. So to Mr. McDermott's point, if it is three angles of the same saw marks on the same bone, then perhaps one would be sufficient unless you're going to tell me that the medical examiner has a particular reason for having taken that photograph in the manner at which it was taken in order to enable them to conduct their examination.
In light of that, Your Honor, I would propose taking out Exhibit 55, 58, and 59. I believe that would eliminate, and you know, the intent of including 55 and 54 was that the different angles I think would aid the testimony, but I think that the expert can testify based off of the one photo. So I would propose taking out 55, 58, and 59.
Okay. So,
Your Honor, did I already object to 53?
You did?
Okay. I'll wait till, did we talk about that one yet?
No, I wanted to start with the saw marks because it appeared to my eye that your point was that, and I thought that was correct, that there were multiple angles of the same saw marks on the same bone, and absent some particular showing of necessity of multiple angles of it, I wanted to see if we could pare that down. Now, going back to the 53, really it's the group of photographs from, say, 39 to 53, which are the various body parts. As a general proposition, their existence and condition in the field is relevant and admissible, right? Those photographs that document that, as long as they're not cumulative, as long as we don't have 7 photographs of the same thing. I believe that starting with 44, it might be, well, no, I think all of them are. Starting with 35 through 53, they're all in the ME's office, right? Those are all as part of documenting. Okay.
Yes, sir. Yes, sir.
Thank you. Other than, Mr. McDermott, is your argument that, I think I heard one argument, which was that they are the photographs 35 through 53 are cumulative of photographs in the field and don't need to be shown again. Do you also assert that photographs between 35 and 53 are cumulative of one another, but there are multiple photographs?
In some cases, yes, Your Honor.
Okay. So the same request I made earlier, Mr. Fawcett, and I trust that you endeavored to already do that, but to the extent that the photographs taken in the medical examiner's office are necessary and relevant to demonstrate how the examiner examined the remains to arrive at their opinions, I think those are relevant and admissible despite their graphic nature. Thank you. But I would also want to avoid needless repetition of the same photograph.
In further, further effort to comply with the court's instruction, I would propose eliminating 39, 38, and 35. I believe that would eliminate the 2 photographs of the head. There would just be the head in the field. Mm-hmm. 39 would be I believe, looks like a knee portion to me. There would still be that photograph of that in the field, and it might benefit the jury that it's not as close up as that. Mm-hmm. And then 35, which is the neck. So I think
35 is the head.
35 is the head. Okay, so then I would take out 38.
Okay.
And I think 36 and 37 are representative of, I think, both sides of that neck column, so I would propose that.
Okay. Mr. McDermott?
Well, I'm fine with those deletions. I would also ask that 53 be deleted because it's repetitious of 56. And although I think there's a question to be asked fairly, on 53 you can see the kind of connective tissue at the far right side. If that was part of the examiner's testimony, that that's how part of how the leg was removed or something of that nature, it would be more relevant. But I would say choose between one of those 2 photos. I would prefer 56 because it's less gruesome.
53 and 56.
They're the same bones from different angles.
Mr. Fawcett?
I'm fine with that, Judge.
Okay, so which one?
53.
I'm sorry, you'll remove 53 or you'll remove 56?
I'll take out 53.
Okay. So what I have so far is the state has agreed to remove 35, which is a second photograph of the head, even though we have a close-up of the recovered head in the field, which is remaining in evidence. That the state has agreed to withdraw 38, 39, 53, I'm sorry, 50, 53, 58, and 59. So with those, agreements to remove those photographs, Mr. McDermott, other than your objection to the nature of the evidence and its graphic nature, et cetera? Do you still specifically have other objections you wish to make a record of?
Unless I wrote them down and you have it,
Yes, sir.
then no.
Okay. Well, to try and be as clear as I can, to make the record as clear as we can, Mr. McDermott moved to exclude 35, and 35 has been voluntarily withdrawn by the state. Mr. McDermott did not move to remove 38. He did move to exclude 39 through 42. The state has agreed to remove 39, but to keep 40, 41, and 42. So to the extent necessary, I'm going to deny Mr. McDermott's motion to exclude photographs number 40, 41, and 42. Mr. McDermott moved to exclude 44, 46, and 47. I'm denying that motion. As to Mr. McDermott moved to exclude photograph 50, the state has agreed to remove that one. Mr. McDermott moved to exclude 51. That motion is denied. Mr. McDermott moved to exclude 53. 53 has been voluntarily withdrawn by the state. Mr. McDermott moved to exclude 54, 57, and 59 that are various angles of saw marks. Other photographs in the packet that the state has offered, including 55, 58, and 59, are various angles of those same saw marks. And the state has agreed to withdraw 55, 58, and 59. And based on that showing, the defendant's motion to exclude 54 and 57 are denied, and the defense's motion to exclude 59 is granted because the state agreed to withdraw it. Anything else, Mr. McDermott, about the photos?
No, Your Honor.
Okay. Mr. Fawcett, anything that we need to take up before we get started with the evidence?
No, Judge, if I could just have a few minutes to take out the exhibit.
I was just going to say, yeah, and I'll run through them again. You have, my notes indicate, agreed to withdraw 35, 50, 53, 58, 59.
Yes.
Is that going to give me enough time for a comfort break?
Yes, although I do have all my jurors, so as soon as y'all can get back and be ready, we'll be ready.
Yeah, regarding the grooming order again,
Yes, sir.
we're being told by the jail that they have lost their clippers. And I don't know if there's anything you can do about that, other than maybe scold them mightily. But it would be very helpful. I got to do what I can.
Thank you.
Thank you.
Hey, deputies, can you do me a favor? I entered a grooming order 2 days ago for Mr. Wolfenbarger. He's still not been allowed or enabled to have a haircut. If I could ask the two of y'all to please prioritize that and communicate it to whomever you need to so that that can happen today in advance of tomorrow, I'd appreciate it. Thank you. Anything else, Mr. McDermott? Okay. We have everyone back, and I'm told that we have all of our jurors. Are we ready to get started yet? I don't want to rush Mr. Facetas for a moment.
Yes, Your Honor. I just would let the court know the first witness does require a wheelchair,
Okay.
so he may take a little bit of time to, but should I go ahead and tell
Is
you?
that person going to be able to get on the witness stand, or are they going to, we're just going to,
Probably on the side or the front or however you would do it.
okay, are we concerned at all about volume?
Can't know until he, maybe.
Okay.
Is there a portable mic that we could get a hold of?
Technically, these things, although they are affixed very well, are in fact removable if it came right down to it. I'm not worried about the jury hearing that person. I'm worried about the court reporter and the other people in the courtroom.
I mean,
Oh, to next week?
Yes, sir. Like the whole base.
I mean, you can do it.
Yeah, he's right here.
And he's going to be right here.
Yeah.
I think
Okay.
that's the best way to do it.
That is the best way to do it.
Okay. State's ready.
Mr. McDermott, is defense ready?
Yes, ma'am.
Okay, we're ready for the jurors. All please be seated. State may call its first witness.
Thank you, Your Honor. State calls George McEachern.
Okay. And if you'll turn around, sir, so that you'll be facing sort of this general direction towards the deputy, where the deputy's standing, if you can. Turn a little bit more so you're facing the deputy so you won't have your back to the jury. That's good, sir. Now, are you able to raise your right hand, sir? Okay. If you would, thank you.
Please swallow a fire. This is the moment you're about to give the court today. Shall you the truth, the whole truth, and nothing but the truth? You may lower your right hand, state and spell your name for the record, please.
George W. McEachern. That is spelled MC after VACH.
Okay. Mr. McEachern, this is the judge talking. I'm behind you, so don't worry about that. If you could, just because you don't have a microphone, if you could just try to speak up when you're answering questions to make sure everyone in the courtroom can hear you. Okay, sir? Thank you. Go ahead, Mr. Wilson.
Thank you, Your Honor. And you live in Atlanta, sir? How long have you lived there?
28 years.
And did you ever live in the area of Avon Avenue, in the general area?
I do, sir.
Do you still live there?
I do, sir.
How long have you lived at your present address?
Well, that's been 49 years.
Yeah. Okay. Thank you. What did you do? What did you do for a living?
I want these things for my son.
I apologize. We can't hear him.
I work at
Hold on a second, sir. Should I try to get the microphone?
I'd say give it a try. Taped together.
Would you like to try?
Yes, please.
That suck.
It's coming though. I can see it moving.
All right.
You see if you can get closer to the microphone that we have there for you, sir. Yes, sir. Mr. Yes, for now. Hang on. I apologize. Why don't you have him come to the podium, and against all directions, we're going to have him move. We're going to move the microphone. Thank you. Just bend it down towards me. I'm going to have him right here. Yes, ma'am. And then, Mr. McEachern, if you could turn a little bit more and face the jury, please, sir. And now.
Yes, George W. McEachern.
Much
Last-
better, sir.
Last
Thank you.
name spelled capital MC, capital EACHERN.
Thank you, sir. Go ahead, Mr. Wilson.
Thank you, Your Honor. And do you remember in April, at the end of April of 1999, an unusual thing happening an unusual thing you found on Avon Avenue?
Yes, I went for a walk that morning to the bank, and on my way back, I came up Avon Avenue, and as
And what did you see?
I saw a head, a human head that was laying in the street. So I walked up to it, and I looked down at it, and I saw it was a head.
How did you know it was a head?
Well, through my training in mortuary science and funeral directing, I recognize human heads.
Human head?
Yeah.
What did you do?
I took a stick and I moved it out of the street to the curb of the road,
Why did you do that?
so it would be intact. I didn't want anybody, another vehicle to come and crack it up. So I moved it to the corner.
Could you repeat the last part where you said, I think it said crack it?
I did not want a vehicle to come and run over their head and deform it. Because I saw it belonged to somebody.
What did you use to move it?
I broke off a stick. And I took the stick and I was trying to push it over to the curb.
Did you see anything else unusual on Avon Avenue on that day? I mean, was there any other things that you can recall?
Well, I didn't know some birds, some birds flying up in there, looked like buzzards.
Okay.
And I recognized that might have been the reason why they were there. But I told the officer after I called them that I thought there could be something else out there in the woods because the buzzards were still there.
Okay.
Yeah.
Now, after you found the skull, what did you do next?
I went home. I got my daughter because she was in criminal justice,
Okay.
and I wanted her to see the head.
Okay.
Yeah,
And did your daughter come with you?
she did.
And what did you do next?
Called the police.
Okay.
Called 911.
And after you called 911, how long did it take? Do you remember how long it took the police to get there?
That recognition said, baby, right now. It wasn't long. But right now, I cannot recall how long it was.
Okay.
But they
you didn't
did.
think it was long?
No, I didn't think it was long. But
How
they,
many police? Do you remember how many police showed up?
no.
Was it just one or more than one?
I don't know. I know there were one.
Okay.
I do know there were one. There could have been more than one, okay?
Because you talked to the one?
Yeah, I talked to the one, yeah.
Okay. And did you do any? Did you go anywhere after you initially told the police out on the scene? Did you go anywhere with the police?
I do know I had to go downtown.
Okay.
But I can't recall whether it was the same day or not, or whether it was a few days later. But I do know I went down to the Atlanta Police Department.
Okay.
I think it was down there, Georgia State College, Ponce Leon, somewhere down in there.
You went to the headquarters?
I went to the headquarters, I think it was.
And I assume
Yes,
you told them what you saw?
I told them the same thing I'm telling you now. Yeah.
And do you remember if you gave any statement or had to sign a statement or anything, just saying what you did?
I'm pretty sure I had to, sir. I'm pretty sure I had to.
I'm going to show you a piece of paper. Do you recognize that?
Mm-hmm.
Is that your signature?
That's my signature.
Yeah. Could you read it real quickly? Is that the statement that you gave?
Sir, I'm going to be honest with you in the courts. When I gave this report, I was walking, I was younger, I could see better.
Well, can you read it now?
And right now, I cannot make this out.
Okay.
They too damn around. I don't have my glasses with me.
Are they around?
I don't know. But baby, have a glasses like that?
Mr. Wilson, just to clarify, are you asking the witness to read it to himself, or are you asking him to read it out loud?
Read it to himself to see
Thank
if
you.
it refreshes any recollection.
Okay. Look at the mirror. Thank you.
Do you need some assistance, sir? Apparently not.
What you want me to do with this?
Does that help you?
Yes, you may read it to myself. I have.
Yeah, read it to yourself real quick.
Okay. It's true, all but a few, maybe a few sentences.
Do you know?
I was driving. I wasn't driving. I was walking at the time.
I apologize. I think you
Say that
said,
again.
yeah.
I wasn't driving. I was walking at the time.
Okay. Did you?
Yeah.
Does that help refresh your recollection
Yeah,
at all?
sure, it does.
Do you remember finding anything else other than a human head?
I don't.
Okay. Now, how long have you lived? You've lived in Atlanta your whole life.
No,
Where else did you live?
no.
How long have you lived in Atlanta?
Ever since 1960.
Ever since 1960?
Yes.
And Avon Avenue, is that located in Fulton County?
It is.
May I just have one moment, Your Honor?
Sure. Thank you. Mr. McDermott, questions for this witness?
Just a couple, Your Honor.
Sure.
Good afternoon. Mr.
Hello, sir. How are you?
Just a couple questions.
Okay.
You said you informed the officer on the scene that there were buzzards certainly overhead. Is that correct?
I did.
And did they go over and check anything else, to your knowledge?
I don't know. They told me they were going to, but I think what happened a few days later, somebody came by my house and told me that they had found another body part, and they were going to try to match the head with that body part. However, as far as I can remember, sir, it wasn't in Atlanta they had found that body part. I think he told me to find somewhere near Griffin or Macon or somewhere down in the area. Somebody told me they had found a body part. And they were trying to mess it up. And that's the last I heard of that.
Is this a walk that you took every day or frequently?
No, this was a walk that I decided I wanted to walk that morning to the bank.
Did you ever normally travel up and down Avon Avenue?
Sometimes.
Did you ever notice any dogs?
Well, there are homes in that area. I'm sure there's dogs in that area
Or did you
also.
ever see any when you were traveling up and down Avon Avenue?
Yeah,
Do you remember? All right, thank you.
No.
That's all the question I have.
Thank you. Mr. Wilson?
No redirect, Your Honor.
Okay. Mr. McEachern, you are excused as a witness. Thank you very much, sir.
Thank you, ma'am.
if you could move that mic back,
Yes, ma'am.
and then we're all going to try not to touch it again. Thank you. Before you have a seat, if you'll turn and face the deputy and raise your right hand.
Do you swear or affirm the testimony you're about to give for today shall be true, the whole truth, and nothing but the truth?
Yes, sir.
You may go to right hand and be seated. Say and spell your name for the support, please.
Careful. That chair is on wheels and there's a ledge next to you, so
Yeah,
make
sure.
sure and stay closer to me than the edge, okay? Thank you, sir.
Dale, Kelly, Kelley.
And what do you do for a living, sir?
Retired,
What did you do before you were retired?
law enforcement for 42 years.
And let's go through your law enforcement career. Where did you first become a law enforcement officer?
In 1979 in the city of Atlanta.
And when you were hired, did you have to get it? Well, tell us about your hiring at the city of Atlanta.
July 2nd, 1979 was the first day I started the Atlanta Police Academy. We were there for 12 weeks, and then after you got out of that, you rode with a senior officer for 12 more weeks in field training. I became a patrol officer. I was assigned to Zone 1, which is northwest Atlanta at that time. 83, I was promoted to detective. I did vice for about 6 months. That was during Eldon Bell. He thought all new detectives needed to go undercover and then come out and get in a regular division. I went to sex crimes. I worked in sex crimes, total of 13 years, but whenever they had a sexually related homicide, I would get pulled over and help the homicide detectives work a sexually related homicide. And then in 1996, I was permanently assigned to homicide.
Were you post-certified?
Yes.
Are you still post-certified?
No, I do not keep my mandated.
Okay. And when did you leave the city of Atlanta?
I retired in 2000 from the city of Atlanta, went to the Douglas County Sheriff's Office, worked there, started in the jail, worked patrol. I went to CID. From CID, I made sergeant. I was a night shift sergeant for a patrol shift. And then I went to the fugitive unit, the warrant unit in plain clothes. And then from there, I made lieutenant and was over the transport and civil division.
Now, did you receive any specialized training in investigations?
Yes, I mean, I've been as far as California on missing persons, violent crime network training. I've been to Valencia College 3 or 4 times on advanced sex crimes, advanced homicide, crimes, and like that.
Now, during 1999 and around April, could you describe what you were in the homicide division at that time?
Yes, sir.
Tell the jury what happens when you get how does that work? Or how do you get assigned cases or what?
Well, okay. You were on a rotation system where you were up on call, and if anybody called for a homicide unit, you would answer and go wherever they asked you to go. You didn't go by yourself. Half the time, the whole unit would go. You were just the lead, and they would do other jobs needed at the scene.
And when you say lead, what does that mean to you?
You were up on call, and the case was going to get assigned to you.
And when you're lead, what kind of things do you focus on?
Well, you get to the scene, you try to focus on directing the identification people to do fingerprints some places, sometimes you don't, take pictures and stuff like that. You may ask some, like the officer, the first responding officer, if there's a witness at the scene or something, you get the officer to take himself and the witness to the homicide office where they could give statements.
And let me draw your attention specifically to April 29th, 1999. I assume you were on call that day.
Yes.
And did you receive a call regarding a unexplained, well, I mean, what kind of call did you receive that day?
The way it works is Zone 3, Unit 2304, which meant he was a day shift unit working 304's beat, came over detective radio and called for a homicide unit. Each zone, and Atlanta still has 6 zones, they all have their own radio frequency. Detective division had their own frequency, and they would just switch their radio over to the detective frequency and call for a homicide unit.
So it was your turn?
It was my turn.
And where were you told you needed to report to?
He told me to come to the intersection of Avon and Hartford Way, southwest in Atlanta.
And what did you do?
I got in the car with the lieutenant, and investigator Tina Miller also rode with the lieutenant, Tony Biello, and we rode to that location.
And why did Investigator Miller accompany you?
Again, on a homicide, you need as many people as you can out there. We didn't know what we had other than a unit calling for us, and we could always use help.
Okay, so she went along?
Yeah.
Okay. And when you got to that location, what did you observe?
When I rolled up, there was a decomposing head in the road standing upright. There's an old black plastic bag to the side, and there's an old mangy, like a stray dog with matted hair and all, kind of nasty, running around out there.
Okay. And do you recall where that skull was located?
It was on the side of the roadway well, it was actually on the Avon side, because we used the address of 858 Avon Avenue.
Now, when you're investigating a crime scene, is it important to document information?
It is, yes.
And you document through reports and also pictures?
Well, I didn't take the pictures. I called for our ID section to come take the pictures, and it's up to them to document their pictures.
Okay. No, what I mean is that it's important to take pictures of
Yeah,
crime scenes,
yeah,
right?
yeah.
Okay. May I approach a witness, Your Honor?
Yes.
I'm going to show you what's been marked as State's Exhibit 3 through State's Exhibit 20. Would you please look at those and tell the jury what those are?
They're pictures of the general area of where it was located, and ID had saw certain objects. They put the little plackets up at, and it's,
Could you look through those, please?
yeah.
Thank you. pictures of what you observed that day?
Yes.
Your Honor, at this time, I'd ask to admit States 3 through Exhibit 20, which are photos of the scene.
No objection.
Okay, Mr. Samuel, thank you. Exhibits 3 through 20 are admitted.
And I would ask to publish some of the pictures to the jury as we go through the testimony as far as
Okay.
a warning.
Thank you. That's what I was waiting for you to ask.
Yes.
So, ladies and gentlemen, as we discussed during the process of jury selection, I told you that I would warn you when we were going to show you photographs that are maybe graphic in nature. So I'm giving you a heads up that some of these photographs may be graphic in nature. Thank you. State may proceed.
Thank you, Your Honor. Okay. Show you what's been marked as, or what's been admitted as State's Exhibit number 3. Could you kind of describe that picture in detail for the jury as best you can?
It's an overall shot of the area where the head was found.
Can you speak up a little bit?
Sir, I'm sorry.
If
It's
you
a
can pull that microphone towards you, I think that'll be easier as well.
It's an overall shot of the area where the head was found, and the head's actually in the photo to the left here, or my left sitting looking at it, and you see where the patrol cars had blocked off the street.
But I do see some yellow things with numbers
Yeah.
on them. What are those?
Plackets, ID team uses, they see stuff, or maybe an investigator will point out to put a placket, take a picture so that it can be described later in their reports.
Okay. And what other items were there other than the placards?
Whether
Or I'm sorry. What other items were there than the skull that you described earlier?
there was a black plastic bag, it appeared to have decomposition in it, hair, and fluids.
And was that significant to you as a investigator?
Yeah, later, when the cadaver dogs were called out, other body parts were found in the black plastic bag, and also had fluid in it that ended up being bleach.
Okay. So when you saw those pieces of evidence, I assume that was kind of the first thing that was kind of done at the scene?
Yes, I cannot legally touch any body out there. It's all up to the medical examiner. I can look at it, I can have photographs taken of it, I can note it, but that's entirely up to the medical examiner's office to do any collection of body or body parts.
Were they contacted? Did you guys contact them, or?
Yeah, they came out to the scene.
Okay, do you recall who came out to the scene?
Mary Beth Happel and Dr. John Parker.
Okay.
The Mary Beth is an investigator for Fulton County Medical Examiner, and Dr. Parker was medical examiner.
Okay. And what did you do? What did you do next?
Well, we started, hard to run an investigation if you don't know who your victim is, and this one's even doubly hard. We didn't know what sex the person was.
Why is that?
The decomposition of the facial and the torso, we never found it. So you couldn't ever determine a sex at that time. The feeling is the torso contains the guts of thing, and it would smell more, and the animals out there would have eaten it quicker.
Okay. Do you recall what the conditions were like that morning?
Yeah, I noted it.
Would you have noted that in your report?
Yeah. As I rode over with Lieutenant Biello and Investigator Miller, the weather conditions to be overcast with a intermittent mist, and the temperature was in the low 60s with a brisk breeze.
So after you got there and after the medical examiner got there, what did you do next?
Nothing could do much other than make a report.
Did you talk to any? Do you remember speaking to any witnesses?
Well, there's a gentleman who had found the head. Gentleman's just in a wheelchair, but he wasn't in a wheelchair at that time. I talked with him. I sent him to the homicide office to give a statement, and the officer on the scene took him there for a statement.
Do you recall any other actions that you did out there at the scene that day?
That day, no.
So at this point, all you had was a skull and some plastic bags, pretty much.
Yeah.
Did anything? Did you find anything else? And on a different day?
On a different day, yes. That's.
Were you called back out to the scene?
Yes, went back out there with the medical examiner's office. They had gotten in some cadaver dogs from Cobb County. These people who owned the dogs were not associated with law enforcement in any way. They were just citizens who trained their dogs to become cadaver dogs and would help agencies as they needed it. And they came back out there, and that's when we started finding hands, feet, and other body parts. They were also in a black plastic bag like I described earlier, and they were always double wrapped. There was always 2 bags per body part. That trying to make sense with me there.
And I don't know, I don't know if you said, do you recall what date you went out to the scene?
The first, it was April 29th, and then this was June 3rd.
So that's approximately, what, a
Month and a half later.
month and a half later?
To get it set up.
Now, is the president, you mentioned bleach earlier, you mentioned bleach earlier.
Yes.
Is that significant to collection of DNA?
Not for the collection, for the destroying of DNA.
Your Honor, you've not been given an expert notice with regard to this witness.
Your response?
Well, Your Honor, I think that's not. I think it's something that a police officer can, based on police officers' evidence collection, could probably could testify to as within their knowledge.
Okay. If you want to lay that foundation, I likely will allow it. Overruled for now, Mr. Samuel. Go ahead.
Okay. Did you learn about bleach?
Well, DNA, it's not the same as today. This was in the beginning stages of DNA. And a lot of things would interfere with DNA. When I worked sex crimes, if there was anal sodomy, the feces would ruin the DNA and you couldn't test it. Learned that bleach and
Where did you
gas,
learn
training
that?
classes I took
Okay.
that would hurt DNA. Nowadays, they probably can do it even if there's bleach on it.
Well, what did you learn about bleach at that time through training?
That it would interfere with the ability to do DNA evidence with what they had to test with at that time.
Your Honor, at this time, I believe I laid the foundation based on his
Samuel?
training.
And we still then never got notice of him being an expert. So if he's giving expert testimony about DNA, you're entitled to be given notice of that.
Okay. I understand your objection, but it's going to be overruled, and to the limited extent you've been asked the question, I'm going to let him answer it. Go ahead.
Thank you. I think he's already answered it.
I think he has.
Okay. What did you do? What did you after you went out and on the in June? What did you do next on this case?
There's nothing I could do until, again, you can't start much of an investigation until you know who the person, what sex the person is, who the person is. You have nowhere to start. So Investigator Miller, who worked adult missing persons, is assigned to homicide. She would attempt to identify the body. Medical examiner's office was trying to identify. They could hook up with other medical examiner's offices and do the thing, and hook up and see if they had any information. I retired in 2000.
Okay. Well, and that was you never got an answer by the time you retired.
No.
Okay. May I just have a moment, Your Honor?
Sure.
Nothing further, Your Honor.
Thank you. Mr. Samuel?
Detective Kelly, my name is Jonathan. It won't happen a second time.
That's okay.
It won't happen a third time. Detective Kelly, I don't believe we've met before, even though we've been around a long time together. So a couple questions. First of all, you said something about a dog on the scene. Do you have any reason to believe that that dog had ever moved the skull at all?
I believe so. I believe the dog drug it out of the woods. And
Oh, you're just speculating about that?
there was a video, VHS recording.
Can you stick with the microphone?
There was a VHS recording at one time that showed the dog dragging the bag out of the woods. Now, I don't know where it's
Dragging
at
the
now.
bag with the skull out of the woods?
Yes.
There was no detectives out there until after the skull was already there.
VHS recording. That's a security camera. It's so old. It was
Where is the evidence of that?
I'm sorry.
Has anybody ever had evidence of that? Is that in any police report anywhere?
I don't know.
Are you just kind of making it up today?
No.
I've read every report you've ever written, every report every other detective has
you haven't
written.
written all written. There are reports missing. I don't know why, but there are some reports missing.
Have you told the DAs there are reports missing?
Yeah. But I mean,
Which DA did you tell that there are reports missing?
gentleman here just questioned me
Uh-huh.
that I had more reports in this file and they're not
And
nowhere to be found.
where's the VHS?
I don't know.
Did you tell them there was a VHS recording that's missing? You told
Yes,
Mr. Wilson that? When did you tell him that?
the other day when he called me.
You told him the other day?
Sir?
You told him the other day?
Yes.
Is there a
Called
reason
me
you...
last week. Yeah,
And what else did the recording show?
just that.
Did it show how the skull got there at all?
Just what I described.
A dog pulling it out of the woods. Where from what part of the woods? Well, it's not in your report, you know that.
I'm telling you, I have reports missing out of this file. This is not my whole file.
Take your time.
It's from the wooded area where we returned with the cadaver dogs. It was coming from that area where the other bodily parts were found in the woods.
What did the dog look like?
Like it was a stray dog. The hair was all matted and nasty looking.
Was there any dog hair found on the skull?
I don't know.
Was there any testing done of the skull to show that a dog had moved it?
I don't know how you do that because it was remember the black plastic bag? It was ripped open. The dog was toting the bag and it fell out.
And you saw a video of that?
Yes,
What did you do with the video?
it was put in evidence.
You know, I think we need to take a break and talk to the district attorney's office for a moment here.
Okay. Ladies and gentlemen, I'm going to ask you to step out for just a few minutes. It's 2:21. I'll try and get you back in here as quick as we can. Thank you all.
All rise for the jury.
Moment, please. Yes, sir.
Okay.
Thank you. Don't wander far, okay? Mr. Samuel, that witness has now left the room.
Well, I have a couple questions. I'd like to know, first of all, whether Mr. Wilson will either corroborate or dispute that he's been given information about video camera evidence that's lost, his reports that are lost, evidence that they knew that the dog had dragged the skull out of the woods into the road. There's no police report about it, and now it turns out his actual statements are missing, all of which apparently he told the DA's office, none of which even comes close to ever having been revealed to us, ever.
Mr. Wilson?
If I could respond to this, Judge, because I was talking directly with this witness on this issue, if the court
Okay.
will allow it.
Sure.
All right. I do have information about the comment about the dog from this witness. We were not able to locate the video. I didn't know there was a video of that description until I had that discussion with this witness. The detectives, Shepard, suspected that there was a dog or dogs in the area that may have carried the head out from the wooded area to the street where it was located. That's been his theory since the beginning of the case.
Right, but inferring that from the presence of a dog that Mr. McEachern testified to is different than we recovered some sort of surveillance video that showed it, but then we lost it.
Sure, and that was never intended to be introduced into evidence by the state. That's why it wasn't elicited during direct. We had a video cassette. We had several small mini cassettes. At the beginning, before the case was indicted, those were submitted to a company in DeKalb, and they were transferred over to a thumb drive, which was submitted in Discovery. And they're labeled as such, converted VHS. It's in Discovery. But that's the only VHS cassette that I received from APD Annex. The multiple times we've gone to, I don't have a VHS cassette.
Okay, hang on. The physical nature of the physical medium in which the state might have it or not have it, I think is less important at this point than does the state have some sort of video that would line up with what this witness is saying he observed, like some digital video recording of that image?
I don't.
Okay. And so the videos that you're saying you were aware of that were reduced by a private company to a flash drive or something and were produced in Discovery, what are those?
Those are all statements. When it, witness interviews,
Okay.
which have been turned over.
Okay.
That's the only VHS cassette that I've seen in this case. A lot of mini cassettes that have also been converted. I only had one VHS cassette.
Okay. I appreciate that. Again, I think it would be easy to identify it if it was a VHS, in your possession. But I think more importantly is, does anybody know that such a video ever existed, whether on VHS or anything else?
I didn't have a documentation of that in the Detective Calhoun's report. I didn't have documentation of that in Detective Shepard's report. And I didn't see any reports that Detective Kelly had written that elicited that information. And of course, all the reports that I have from Detective Kelly appeared to be complete.
Okay.
I had no reason to believe they weren't. But, so like I said, I never intended that this information would come in because I didn't have a way to authenticate it. Other than that detective's testimony, I knew that wouldn't have been permissible to elicit it. He had just him testifying to it.
Okay.
I never intended for that to come out.
Mr. Samuel? I think the answer to your first question is, well, actually, to be honest, now that I'm trying to put it in words, I'm not actually sure I'm clear on what the answer is. And that was why I was trying to make the distinction between the VHS and the video.
Yeah. Let me explain to you how I see the problem. We have been working on this case, Mr. McDermott in particular, 24 hours a day, 7 days a week for Lord knows how many months at this point. He's been in communication with the DA's office. There's been a lot of open file. And yet apparently they're not telling us about evidence that's lost, about videos that are lost, about their second witness on the stand who's saying he was the chief investigator in the case and some percentage of his reports are lost. Now, either the DA's office says they were oblivious to all of that and they learned that the same time I did, or they've known it all along and didn't tell anybody. Meaning you, us, the destruction of evidence, the loss of evidence that may be important, the loss of police reports from witnesses, from a chief investigator from the original crime scene. He says his reports are missing, and nobody's telling us that the witness is just going to, blurt that out on cross-examination for the first time. And, this business about bleach is not in his report. There's references to bleach in the report, but according to the crime lab that we interviewed, it had nothing to do with bleach in the bags. It was bleach that was done by the crime lab to clean the bones.
And that's a matter for cross-examination.
Well, but he's saying now he's saying I've got bleach in the bags. There's no report anywhere that says that.
And again, that's a matter for cross-examination unless there is some report that has not been provided to you. But I'm going to ask you to put a pin in that for a moment and revisit this with Mr. Fawcett or Mr. Wilson. I'm still not sure I understand the answer to the question, which is, before Detective Kelly took the stand, did the state have an understanding that he believed there were other reports that he had made that were missing, number one, and number two, that he believed there was a video showing what he's described about a dog with a bag in its mouth pulling it into the street, which was containing some body part or other? Two questions. What are the answers to those two questions?
Yes, I was providing that information last week when I spoke with him.
Okay. And what efforts did you take to determine if such evidence did in fact ever exist and or was lost or in your possession?
Well, I went back through the file to see if there were additional reports by Detective Kelly. So the reports from Detective Kelly, I sent him portions from the file that we turned over. I went through our additional discovery. I saw additional reports that were turned over. Similar reports to the first one. They were 1 or 2 pages, so not what he's discussing. But I wasn't able to locate any additional reports by Detective Kelly, and that's been through the several times that I've gone through the discovery.
Okay. Okay, so you were aware that Detective Kelly believed that there were other reports that were not in your file?
That was last week, yes.
Okay, but I understand you only became aware of it last week, but you did become aware of it at some point.
That's correct.
And what about the second question, which is, were you aware that Detective Kelly believed there was some sort of surveillance video that had been recorded at the time that reflected what he's described?
Yeah, that's the same conversation.
Okay.
Week, yes.
And did you disclose, and I'm not implying here that you were obligated to, we can have that conversation in a moment. My question though is, did you disclose to the defense at any time that Detective Kelly believed that there were reports that were missing, or that he believed there was a surveillance video that was missing?
I did not have that discussion, no.
Okay. Mr. Samuel, I think I've gotten the answer to those questions. Go ahead.
Well, I have the same, the first question says, why would you not disclose that to the defense? That we're going to put a witness on the stand who, in essence, is going to ambush you on cross-examination because you think, defense counsel, you have all of his reports. We know you don't. So if you cross-examine him, you're going to find out that he's going to say, oh, that's absolutely true. I have got additional reports. They just were never given to you.
What obligation does he have to disclose to you?
The prosecution has an obligation to report missing evidence, right? A VHS camera. He can't just say, it's missing, so I'm just not going to bother asking questions about it on direct examination and let the defense attorneys walk into a trap where the witness can say, oh yeah, what other videotapes are missing? Do they have a videotape of the crime being committed they haven't told us about that was lost? I mean, this is somewhat not the most important thing in the case, whether the skull was dragged out of the woods or wherever it came from. I'm just very concerned if by witness number 2 we're discovering that the prosecution knows there's missing evidence, missing surveillance cameras, missing police reports. They know that that's true, and they're not even telling us about it. It's bad enough that they're missing, which is understandable after 20 years to some extent. It's not understandable why they wouldn't tell us.
So the question then, Mr. Samuel, is what relief would you have the court give you in light of the fact that it wasn't disclosed to you? Is that not something that you can remedy on cross-examination and with this witness and argument?
I have no idea what he's going to say because I have no idea what this witness is going to say that hasn't been disclosed to us. The whole point of discovery in a criminal case is you give us your witness statements. Now it turns out he knows a lot more about this case.
I understand.
Did they know?
But
The
that wasn't my
prosecution
question.
knows.
My question was, what remedy would you have me fashion to address this issue if I agree with you that this is a problem? Is it go talk to the detective and figure out what he's going to say before you have to cross-examine him in front of the jury?
I was actually going to suggest that you tell the jury, disregard the witness's statement as of now. At some point later in the trial, if they want to bring him back after disclosing to us the statements he gave to them that's missing from what they gave to us, if there's something more than the VHS, something more about the bleach, something more about whatever I haven't, stumbled upon yet. When a witness talks to them, that's a witness statement also that hasn't been turned over to us. Not just the witness statement that's lost, but what they told him, what he told them last week is a witness statement that hasn't been disclosed to us. You can't interview a witness, find out relatively important information and say, I'm not going to put it in writing, so the defense attorney's never going to learn about it.
Understand. Thank you, Mr.
I would ask that the witness you tell the jury not to pay attention to what the witness has testified to, and we'll bring him back later in the trial if appropriate.
Thank you, Mr. Samuel.
After the prosecution does what it's supposed to do.
Mr. Fawcett?
Yes, I think I could understand, still wouldn't agree with it, but I could certainly understand Mr. Samuel's position if we were going to take his, I guess where he's going with it, there's some nefarious intents and bad faith on the part of the prosecution to do that. I will say I am not immune to oversight or overlooking items, but hindsight I would have. But I will say this: I had no intention on not turning that information over. I didn't think it was of any consequence. I thought at the minimum it would benefit the state. But finding that information out on a Friday or a Thursday before the trial, I did think that was somewhat of an ambush. And again, also at the same time, I would say this. I believe the defense has contacted just about every witness that we've had on the witness list since the beginning of this trial. Detective Kelly's name has been in the discovery. Since the discovery was turned over, there are 3 total detectives, and I know for a fact they've subpoenaed detectives from the patent investigation. And so if they had called the Detective Kelly, he would have been willing to speak with them But to infer that there's some nefarious intent in the process of just simply preparing for trial and interviewing the witnesses, I think it's a bit much. At a minimum, at a maximum, I can understand the court, we're going to instruct the jury to disregard the last statement, but to instruct the jury to disregard the entirety of his visual observations and testimony about that when he arrives at the scene, I don't believe there's any reason for the court to decide in that manner.
Okay. I have a couple of questions. Let me try that again. Has the defense spoken or attempted to speak to Detective Kelly prior to today?
We have not, Your Honor, and I'm looking for the state's witness list that was sent to us currently because I don't think we were ever given any contact information for him, and he's retired, so usually not kept by the police department.
That the state provided does list Detective Kelly as Detective Dale Kelly, APD.
Okay.
So, that doesn't actually answer my question. Is your answer that you haven't attempted to contact Detective Kelly because you weren't provided contact information and you weren't able to otherwise locate him because he's retired?
That wouldn't be 100% honest, no.
Okay.
If I could say, I'm not sure the blame should be on us.
I'm not implying that I'm blaming you. I'm asking what information did the defense have that they could have exercised in terms, right? I'm just trying to understand the scope of this. It'd be one thing, for example, if y'all had tried to contact the detective and he'd refused to speak with you. That's what I'm trying to figure out. So
I understand that's your question. I'm not quite sure the consequence of it. If we trust the prosecution, that when they give us the reports, we have the reports. If we have to go and consult all 18 of the witnesses on the list now, all 30 of the witnesses last week, and all 150 in the original list, and say what is missing from your police reports, this case wouldn't have been ready to be tried this year.
okay.
But
Thank you, Mr.
understand
Samuel.
your question.
So I still think that the answer to the way to resolve this in the most expeditious manner is for y'all to go into that conference room with Detective Kelly and find out what he's going to say is missing from his report. Because whether or not Mr. Fawcett should have told you is a different matter than whether or not this detective can testify truthfully about what he believes happened in response to questions. Mr. Fawcett is correct that they didn't solicit that testimony. And to the extent that you believe you've not been given complete information, Mr. Fawcett has made representations about what additional information he believes there is. And you can ask Mr. Detective Kelly those questions while we wait and bring the jury back in. I don't think, it's 2:40. I feel like an initial conversation with that detective to find out what else he's going to say and how many reports he thinks are missing. That's a fair conversation for y'all to have before I decide what to do about his testimony, or to simply have him retake the stand and let's continue his cross-examination with you having the benefit of the additional information that he believes is missing. Mr. Fawcett? Or Mr. Wilson? I think he's technically your witness, but.
He is. And so the court's going to go in, would the court allow a recess for them to speak with the witness?
Yes, that's exactly what I'm proposing.
I think that's the way to do it.
Okay. So, Mr. Wilson, if you will go and gather Detective Kelly, and y'all can either discuss it in the lobby or you can go into that conference room in the atrium there, or you can go in that conference room and discuss with him what items he believes are missing or that sort of thing. Thank you. We are in recess until 3 o'clock, or if y'all come back sooner than that or later, tell me. Okay, Madam Courtwoman, you ready?
Yes.
Okay. So we took a break at 3:40 so that y'all, I'm sorry, 2:40, thank you, so that y'all could go and talk with Detective Kelly. And then after that, let me know what everybody thought in terms of what we need to do. Mr. Samuel, have you had an opportunity to talk to Detective Kelly?
I have, and he answered a couple of questions that were very helpful, and he explained what police reports he thought were missing and described them. He doesn't have anything more to say about the VHS. We're probably going to steer clear of that. We still think it ought to be excluded, that you should tell the jury to disregard that testimony because it's missing evidence. But I'm prepared to go forward. The missing reports deal with the June discovery of evidence, and he explained to me what was in his report, so I'm not walking into any dangerous territory there. And there's an issue about bleach, which is concerning, but we talked about that, and I think we both understand now the bleach issue, which you'll hear when we testify.
On cross. Okay.
A little bit of hearsay on both sides with the bleach, but I think we're in agreement that that's what we're going to do.
Okay, thank you. Mr. Fawcett, it sounds as if we've resolved this issue for purposes of having Detective Kelly come and retake the stand. It sounds as if the only general editorial I'm being requested or ruling is to instruct the jury to disregard Detective Kelly's testimony about a VHS or some sort of video. What are your thoughts on that, sir?
I'm not objecting with that, Judge.
Okay. So what we'll do then is we'll have Detective Kelly return to the stand. I'll have the jury brought back out. When the jury returns, I will instruct them that they are to disregard any testimony from Detective Kelly regarding a surveillance video showing a dog. And then Mr. Samuel can resume his cross-examination.
Yes, sir.
Okay?
Thank you.
Thank you. I'm ready for the jury. Please be seated. Ladies and gentlemen of the jury, in a moment, Mr. Samuel is going to resume his examination of this witness. Before he does, I'm just going to instruct you that this detective's testimony regarding a surveillance showing a dog, that information, that I am instructing you to disregard that testimony. Do you understand? Any problem with complying with that instruction? Okay. Thank you all. Mr. Samuel, you may resume your examination.
Thank you. Detective Kelly, you mentioned on your direct examination something about bleach, and I want to clarify that as well. Am I correct that you don't have any independent knowledge that there was bleach in the bags? Is that correct?
That's correct, yes.
Okay. In fact, what you've learned was that the bleach was put on the jawbone and on the skull at the crime lab or at the medical examiner's office, correct?
Yes, it was.
Okay. So there wasn't bleach in the bags. There was decomposition of
Fluid.
flesh and whatever, but there wasn't bleach that was put in the bag,
No.
correct?
Yes, there's an understanding between me and somebody else.
Speak up a little bit for these old ears.
Yes, you're correct.
Okay. All right. All right. Now, you indicated before that you were missing some police reports, right? Or at least one. And during the break, you and I had a quick conversation, right?
Yes, sir.
And the police report that's missing is the one dealing with the second time you all went out to the scene. The first time is in April, the second time is in June. Is that correct?
Well, I was provided more reports that I did not have or was not given to me at this time. And then the one I'm referring to now is 6/3 of 99.
Right, and that one you don't have, and nobody has, but you and I discussed it, so it's as good as if we had a police report, right? Okay. So in June, you go back out there, and you're in the same general vicinity or somewhere out there, is that right?
The wooded area,
Wooded area.
Yeah.
You're not on the road anymore.
no, sir.
And there are, now we have black plastic bags, no bleach or anything, but black plastic bags that have different parts of the skeleton, frankly, right?
Of human remains, yes, sir.
Human remains, okay. And you gathered those up, and they all get sent to either the medical examiner or the crime lab, correct?
Well, no, I did not gather them. I did
You were
not
present.
touch. I was present when
Yes.
it was being done. The medical examiner's office was there. They took custody of them immediately.
Right, and they've taken me either to the Fulton medical examiner or eventually the crime lab, or someone we'll be hearing from later on in this trial.
Yeah.
Okay. Now, did you actually see where the black bags were found in the wooded area? Were you watching as they were collected, even though you don't put hands on them?
Yes.
Okay. And the people who were putting hands on are
Medical examiner.
they wearing gloves?
Yes.
I'm sorry. We have a problem.
Medical examiner.
Double problem. My ears and your soft voice.
Medical examiner and their investigator that was out there.
And they wear gloves, correct?
Yes. They
Okay.
wear gloving.
Right. And so on these bags, if there's DNA evidence on any of these bags, presumably it's not going to be crime lab people or detectives because you all are too careful about that, right?
They were. I was not touching anything.
Right. You don't touch them, and they're wearing gloves like you
Yeah.
see the crime lab people on TV always doing. Okay. Now, were these bags buried?
I remember some of them were buried very shallow.
Okay. So just kind of give us an overview. That you're in a wooded area that like buried under leaves, or did you have to use shovels to dig dirt out?
I don't recall.
Okay, fair enough. It's 25 years ago.
Yes.
There were paths through the wooded area. Do you recall that?
Yes.
Okay. Were some of the bags just simply placed on a path?
I don't recall if they were placed simply on a path or not.
Okay, well, you wouldn't know. Placed is a verb that you wouldn't know, but were they located on the side of the path or right in the path?
I'm going to say on the side.
Okay, so anybody walking on a path would have seen the bag, presumably.
You would think, yes.
Okay, and it's now June of 1999.
Yes.
Okay. And that's the first time, as far as you know, that those bags were ever moved from the path or the side of the path.
Yes.
Was there any evidence that you remember, and I know you don't have the report, it's missing, but in your memory, do you remember seeing loose dirt as if other people, the cadaver dogs, were digging up the ground as opposed to the bags being on the
I
surface?
don't recall.
Very good. Okay. Those are my questions, Your Honor. Thank you.
Thank you. Mr. Wilson, redirect?
They just have one.
Sure. Thank you, sir. You may step down. You are excused as a witness. State may call its next witness.
We'd call Tina Miller.
Thank you, ma'am. If you'll come up to the witness stand, and once you get here, before you have a seat, if you'll turn and face the deputy and raise your right hand.
You swear or affirm that the testimony you're about to give in court today shall be the truth, the whole truth, and nothing but the truth? Yes, I do. You may be seated, lower your hand. State and spell your name for the court reporter.
Tina, Tina, Miller, Miller.
Where do you work, ma'am?
I currently work for the Gwinnett County Medical Examiner's Office
How long have you worked there for?
since 2018.
What did you do before that?
Prior to that, I worked for the Atlanta Police Department. I retired as a lieutenant in 2014.
Were you a certified law enforcement officer while you were working with the city of Atlanta?
That's correct, yes.
Could you kind of tell the jury about go quickly through your career as a law enforcement officer?
Okay. Right out of high school, I went into the United States Army, where I was trained as a military police soldier. When I got out, my goal has always been to go into law enforcement. I got that basic training there in the military. When I got out of the Army, I applied to the Atlanta Police Department. I was hired in 1984, started my training with them, and retired in 2014. While at the Atlanta Police Department, I served in Zone 6 as a patrol officer. I was promoted to detective a couple of years later. I was assigned to narcotics, where I spent 5 years working undercover and buying and working drugs in the city of Atlanta. I spent 5 years working fugitive after that. Then I went to the homicide unit, where initially I worked aggravated assaults, and then went on to do adult missing persons in the homicide unit.
And could you describe the duties of an adult missing persons detective, what you did?
Yes, any adult missing in the city, 17 and older, would come to my desk, and I would follow up on the case, contact the reporting person, and do legwork in an attempt to find the individual. Typically, what I would do is go out to neighborhoods. If they had a substance abuse problem, I would go out to the neighborhoods they were known to frequent and see if I could locate them, get word on the street that their family was missing them, and I had a pretty good success rate with getting them or finding them.
And were you called in to assist on a case of a skull found in April, the end of April of 1999?
Yes, I was.
Could you please tell the jury what the circumstances of that were?
I was working homicide and doing missing persons, and my lieutenant would have me go out on scenes where situations like that, if we had a missing person or we had somebody, we didn't know who they were. And on this particular day, the call came in that Uniform had responded to a call where there was a human skull in the roadway, and went out there with him and Detective Kelly. So I rode with the lieutenant, and we went out and secured the scene and took information and worked the scene.
And where was that located?
On Avon Avenue.
And was that in the city of Atlanta?
Yes, it was.
Fulton County, Georgia?
Yes, it was.
Did you, when you first got to, what do you recall when you first got to the scene?
Obviously, Uniform had responded, and they had blocked off the roadway with crime scene tape. And I remember seeing the skull sitting upright in the roadway with a white stick in front of it, or a painted white piece of wood. And there was a black trash bag, and also various items that had probably come out of the bag or off of the skull in the roadway.
And is it, I know you didn't do it, but is it important to document the crime scene using photographs?
Absolutely. Absolutely.
I'm going to show you what's been previously marked as State's Exhibit 21 and 22. I'm sorry, may I approach?
Yes.
Are you familiar with those?
Yes.
What are they?
They are crime scene photographs of extremities in a black trash bag that were found by me later when we went back out to the scene to search for additional remains.
And are those accurate, true and accurate depictions of the scene?
Yes, they are.
Or at this time, I'd ask that 21 and 22 be admitted into evidence.
Mr. McDermott?
Objection.
Okay. 21 and 22 are admitted.
Now let's go back to the 29th of April. I'm going to show you what's been previously entered as State's Exhibit number 3.
Do you mean the 28th of April or 29th?
29th of April, 2000.
Is that the initial call?
Yes.
Okay.
Okay. Right. Now you can see on the you can look on the screen. And that State's Exhibit 3 is that shows that depicts the scene at Avon Avenue.
Yes, it does.
Could you kind of point out to the jury what significant things are on the street?
Am I pointing up here?
Yes, actually, that's probably a good idea. Your Honor, may the witness have permission to leave the stand to help?
Sure, just a reminder to speak up so that the court reporter and the rest of the courtroom can hear
Okay.
you. Thank you, ma'am.
Here we have the skull, which is now sitting upright with the white board in front of it. Here's the black trash bag, and these are items that either came out of the bag or came off the skull, because the skull, it was believed, had been struck out in the roadway.
Did you closely observe that skull?
Yes,
And did there appear to be damage to the bone structure?
yes.
And what damage was there?
I can't recall specifically, but I can't recall specifically. Because there were pieces.
Show you what's been marked as States 4. And what does that show?
That shows, again, a different angle of the scene where it's down toward, I believe it's down toward Hartford, looking up Avon Avenue.
And what is significant in that picture as far as this investigation?
Again, you could see the skull, you can see the back black trash bag, and other miscellaneous like parts that may have been skin or bone.
I'm going to show you what's been marked as States 5. What does that depict?
Closer photograph.
Show you State 6. Is that a different photograph of it?
Yes, this is more toward the railroad tracks, looking back to your right.
I'm going to show you what's been marked, or what's been entered, in State's Exhibit number 11. And what is that a picture of?
That is the black trash bag.
There's a yellow card that has, for lack of a better term, the number 2 on it. What is
Correct.
that?
That is a marker that was, I believe it was put out by the medical examiner's office to indicate later that they could diagram what was there by the number and reference it later as to what was there.
Okay. I'm going to show you what's been marked as State's Exhibit number 15. And that is?
That's the actual skull in the roadway.
And where was that? Where was that in location to? Are you familiar with the business next or very close named Action Glass?
Yes,
How far is that away from Action Glass?
not very far. It's, if you walk back on the other, behind, like going to the right here, you would go to the intersection and the glass company is right across the street at that intersection.
And if you observed the skull, was there any decompensation or decomposition
Yes, it was.
about that skull? How would you categorize that?
Advanced decomposition.
As the skull sat there, were you able to make any identifications at all?
Absolutely not.
Could you tell anything about it other than it was a skull?
No, not at all. Not on that particular day, no.
How long were you out at the scene?
Probably a few hours.
And did you do anything? Did you do anything else at that scene on that day?
I assisted with anything that the homicide investigators needed to be done, and I also assisted Mary Beth Hoptel in photographing by just showing her, pointing out different items in the roadway that may be related to the skull.
Okay. But she actually took pictures?
Absolutely.
Not you?
No, I did not.
What else did you do that day?
I believe that was it.
Okay. Were you out there on a different, well, did you do any, what work did you do on that case starting that day?
Well, initially, the case was handled by a homicide investigator. And once the medical examiner's office collected the remains, because basically they handle remains or a decedent on the scene. And I was in communication with them and assisting the homicide detective in trying to find out who this individual was.
Was it important to find other parts of the individual?
Yes.
And had you been able to do that yet?
No, not at that time. Not that day, no.
Okay. So what's the next significant day that occurs in your investigation?
The next time was probably, I think, June 3rd of '99. Initially, there was some question that particular head belonged to an individual that was not in the Atlanta area. The investigators were able to determine that head did not belong to the individual in Middle Georgia. They found all of their remains. And it was determined by dental that our skull did not go with that body. And so my supervisor suggested that I get a cadaver dog, and a cadaver dog is trained to sniff for human remains and go back out there, which we did.
Well, who all went out there with you that day?
The medical examiners had sent investigators out, and also the homicide unit was out there. And because the area we were going to check was railroad property, we had 2 railroad detectives as well assisting us.
And you remember what side of the street the skull was found on?
Correct.
Was that where you were searching?
We were searching, there's a wooded area which would be across from the skull, and we were searching the other side of that as well as that wooded area.
And were you able to find anything?
No.
How long were you out there searching?
Probably all morning.
And you were also using a cadaver dog?
Yes, we were.
And there was, how many people do you think there was approximately?
Maybe 8.
How long did you stay searching at that?
They stayed for several hours, and then another call came up, and when the other homicide call came up, they all left to go handle that call, and me, the dog handler, and the 2 railroad policemen stayed.
And what happened next?
We were standing there discussing, kind of what to do next or further options, and a gentleman that owned the garage on the corner came out, and he said, you might want to check the wooded area behind my shop. He said people use that as a cut through, and there's people back there doing drugs, and you might want to check that, and we did.
And what did you find?
The railroad policeman didn't go with us, but me and the dog handler entered the wooded area, and there was kind of a path, so we're kind of walking through the path, and I'm following the dog, and the dog kept going, and I noticed off to the side a black trash bag, and I picked up the trash bag, and it was rather heavy. I opened the trash bag, and an item of clothing fell out, and it looked kind of moldy and off-colored. Well, there was another bag inside that was also it was heavy. And so I pulled it open, and when I pulled it open, I saw flesh. And I pulled it open a little more, and I saw the beginnings of toes on a foot. And at that point, I realized we'd found additional human remains, and I believe that to be a female foot.
Okay, who all was out there at that point?
Me and the dog handler.
And then what did you do next?
At this point, the dog had gone ahead of me, and the dog went around to an area kind of behind where I was, and found the leg and thigh that was in that photograph.
Okay, and let me go ahead and have you take a look at States 21. And what is States 21 describe?
That is the thigh, lower leg bone that the dog hit on. Or
Was
loaded on.
that originally in a bag?
I believe so, but not when we found it,
Okay.
because there's a trash bag that was nearby.
I'm going to show you what's been marked as States 22. Could you describe it? Ed, what is that?
That is a black trash bag.
And was there anything inside of that?
Now, I can't tell from that photograph if that's the one that was next to the thigh and lower leg bone, or if that was another one.
How many trash bags did you find out at that scene?
I actually just dealt individually with the 2, but other bags were recovered. Once I found realized what we had, I immediately contacted my supervisor in homicide to let them know we had additional remains and they needed to return to where I was, my location.
Now let me ask you this: how far were those bags from where the skull was initially discovered?
Not very far. The street ran in front of the little junkyard car repair place. This was directly behind it, so not even a block.
And how long did you stay on the scene for that?
Several hours, because the medical examiner's office came out. We, searched that area and found the additional bags, and then they collected them. After they documented where they were, photographed them, then they collected them.
And there's a business action glass.
Yes,
How far was action glass from the discovery of the additional evidence on the third video?
right across the street.
So within
50 feet, if that far.
what did you do next?
On that particular day, again, the remains were collected by the medical examiner's office, and they were taken to the medical examiner's office for the examination. And I assisted the homicide guys with whatever. I had gone back and I checked again for my records, and I did not have a missing person fitting any description in that area.
So what did you do next on this case?
Again, just assisted the. Do you want me to fast forward?
Sure.
Okay, I was promoted out of homicide, and well, before then, I worked with the medical examiner's office in trying to find out, you know, did we have a white male, black male, male, female? What did we have with the skull? And the people, the individuals at the medical examiner's office determined that the skull belonged to a white male. I didn't agree with that, but they were the experts, and so it was listed on the system as a white male. And what we did was we put the individual, we put the skull for sure, and we had to do them separately because at this point we didn't know they were the same person. I put the individual on GCIC, which is the Georgia Crime Information Network, and then there's the NCIC, which is the national database. And in a perfect world, that was set up so that when we put that information in, if there's a missing person that fits that description, as limited as we have, we would get a hit on it. And it would say, hey, look at this person. This may be who this is. That did not happen.
Okay. May I just have a moment?
Yes.
What else did you have to do with this case?
Again, I met regularly with Dr. Terry and talked to her about the case.
Who's Dr. Terry?
She's, at the time, she was a medical examiner working out of Fulton County. She's a forensic pathologist that was looking, at the time, we were working together looking at the unidentifieds that she had in her office and the missing persons I had in my office. And we were comparing notes, trying to get our individuals identified.
Okay, but as far as the scene and everything, that completed your work on this case?
Yes, that completed my work.
Nothing further.
Thank you. Mr. McDermott?
Your Honor, I hate to do this, but I just received, literally just now, about 70 or 80 new photos of this particular crime scene with bags, and I would ask the court to have a brief recess to be able to line some of these new photos up, choose a few to talk to her about those.
Okay.
Cross.
Ladies and gentlemen, I'm going to ask you to step out for just a moment while we get ready to examine this witness further. It is 3:32, and I'll have you back in here as quickly as I can. Thank you.
All rise for the jury.
Thank you. Please be seated. Anything you need from me while you do that?
Not really, thank you.
Okay. Then we are, say, maybe a 10-minute recess until 3:45.
15 when we go further.
Okay. 3:50 it is. Ma'am, if you will step down, you can just hang out outside, but don't wander far, okay?
Yes, ma'am.
Thank you. We are in recess until 3:50. Okay, Madam Court Reporter, you ready? Yes. Okay. We are back on the record after our brief break for Mr. McDermott to review photographs that were provided by the state apparently recently. Mr. McDermott, if you could tell me, are you ready to proceed with the jury?
Ready to proceed?
State ready?
State's ready, Your Honor.
Okay, we're ready for the jury.
I believe I'm looking into the system. If I'm not, I'll take the lumps.
So,
You want me
Do you know how to share your screen, Mr. McDermott? You know what to do?
to? Yeah, I was going to.
there is a, I believe I saw him in the hallway as I was coming in. Can we get our witness back, please? Come on back up to the stand, ma'am. As you're returning to the stand, just since we took a break, I'll just remind you that when you began testifying, you were sworn in and that you continue to be under oath. Do you understand?
Yes, sir.
Thank you. Please have a seat. Mr. McDermott, you may begin your examination.
Ms. Miller, first of all, there's a T.R. Miller in several of the reports. Is that you also?
Yes, that's me.
Okay, thank you. You were called out, were you called out with the group on June 3rd? And that was when the parts were first discovered?
Yes.
Okay. And there was a second group that went out on the 4th. Were you also part of that group?
We're talking about June?
Yes. Yes, ma'am.
I think that was just one day that we were out there,
That you went out?
that we went out.
Okay. So I just want to be clear, you only remember going out one day?
There was the day where we found the remains, and we may have gone back another time and did a grid search.
Okay. That would have been like weeks later or several days later?
I can't recall. I can't
That's
recall.
You mentioned a search that was done in conjunction with the railroad police?
That's correct.
That would have been across the street from Action Glass and the other businesses, right?
That's correct.
And nothing was recovered from that search?
No, it wasn't. The dog, one of the employees from the medical examiner's office was concerned about a black bag that was over there that the dog kind of looked at, urinated on, and kept walking, and turns out there was a dead dog in the bag. So the dog was justified in passing it by.
Was that an active rail line at the time?
I believe it was.
So I want to show you a couple of more of the photos that were taken from the day the remains were found. If I want to show that to her, I want to share my screen now.
If you need her to identify it before you, in order to lay a foundation to have it admitted, you really need to show her in physical form if you are able.
Don't have that.
It is, perhaps you could show it to her on your
On my computer.
screen.
Yeah, I'll do that.
It is possible to only broadcast to one screen, but it's exceedingly difficult. Yes, sir, granted.
I want to show her all four that I have.
Go ahead.
Do you remember, does this ring or look familiar?
Yes.
Okay. I'm sorry.
That's okay.
We have one computer.
No, I understand.
I have five, actually.
Yes. 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 Yes.
So for the record, I've shown you 5 photographs.
Yes.
And those familiar to you?
Yes.
And are they fair and accurate representations of what you observed the day that you were on the scene
Yes.
on June 3rd?
Yes.
Okay. Permission to publish, Your Honor?
I'm going to let you
All right,
publish them, but can you give me a designation for our
These
record?
would be defense 1 through 5.
Okay.
And
And
move those to evidence, please.
defense exhibits 1 through 5. Mr. Wilson, any objection?
No objection, Your Honor.
Okay, exhibits 1 through 5 from the defense are admitted and you may publish.
Thank you. I hope this works. Whoops. My apologies to the court. Perfect. An update is being installed.
Isn't technology great?
And on top of that, I understand you have a plane to catch.
I do, sir.
Fine. Let's see if I can go about this a different way. This will be a little slower, but I'll go one at a time. Finally. And can you describe what's going on in this picture?
That appears to be the area where the thigh and leg bone, lower leg bone was.
Okay. And does that appear to be in a, what you described earlier as a kind of a walking path or a cut through?
That's actually, the walking path is further over to like the upper part of the screen. This was a lower area closer to the street.
Okay. So that was close to the street or closer to the street?
Closer to the street.
Okay. All right. And is this the same item
Yes, it is.
from a different perspective? Okay.
Yes, it is.
All right.
For record purposes, was that D1 and D2?
Yes, ma'am.
Thank you.
Now displaying D3. And can you explain what we're looking at here?
It looks like one of the black trash bags.
And is that in kind of a clearing or a little path? A little
It looks
path?
like it may be off the path.
Okay. Is it visible from the path?
I don't recall. I don't know where the photographer was standing in relation, if he was on the path or she was on the path.
Okay. And what are we looking at here? Defense 4.
Another trash bag.
And can you remember or recall the general location of this as to where you were looking?
No, not without looking at a diagram.
Okay. And final one, Defense 5. What are we looking at here?
Again, that looks like trash bags, and if I'm seeing this correctly, that looks like the thigh and lower leg bone over to where the number 2 is.
Okay. And again, the same difficulty with the location?
No, it's going to be, if that's the leg bone, that's going to be on that further side.
Okay. Further side meaning from Avon Avenue back further behind the business?
If you come in off Hartford,
Okay.
this would be to the right more so than where the foot was that I recovered.
Okay,
This
I
would
see.
be off to the right. It
Is it-
appeared at the time that perhaps an animal had tore open that bag, and it was off to a right, more toward the street.
This one, this bag here?
Correct. Again, if I'm seeing that correctly, and that is the thigh, there was a bag nearby that thigh.
Is it fair to say that this is not stuffed back in the brush?
No, this was, the thigh and the lower leg was pulled out from the brush.
Well, did you see it pulled out?
No, it was found,
Right there?
right, it was found not in a bag anymore.
Okay.
With
But
a
in that
bag nearby.
location?
Yes.
Okay. And as it is in that location, it's not shoved up in the brush or anything?
No, it appeared to have been pulled out of the brush. It was more in a clearing area.
Thank you. You said one of your jobs was to point out items that may have been associated with the skull in the road. This is, of course, going back to April 29th. Is that correct?
That's correct.
And did you find any other items?
Just the pieces that appeared to have either come out of the bag or off the skull.
And some of those were far down the road, correct?
They were a little further down, not too far, but further down.
And is that what you were referring to when you said it looked like it had been possibly hit by a vehicle?
That's correct.
Okay. No further questions, Your Honor.
Thank you. Mr. Wilson?
Thank you. Very briefly.
That's fine. Thank you.
May I approach?
Yes.
Thank you.
Okay.
And I've shown you a picture of exhibit number 2. Do you recognize that, what that is?
Yes, I do.
What was that?
That's the area, and it's an overview of the area where the skull and the additional remains were found.
And is that an accurate description of how the streets and how that part of the town looked?
Yes, yes.
Okay. Your Honor, at this time I'd ask that states number 2 be admitted into evidence.
Any objection?
No objection.
Exhibit 2 is admitted.
I'd go ahead and publish that.
Go ahead.
Thank you. Okay. Can you step off of the stand and point to where the skull was?
Okay. Your Honor.
Or actually, first,
Okay.
before you do
Yes.
that, can you just describe what that is for the jury?
It's an overview of that neighborhood. It's a little different now than it did back then, obviously. The skull would have been found in this area, right here, right in here. This was at the time, I don't know if it was a junkyard or a mechanic shop, but there was a gentleman that either owned that or worked there that was the one that referred us back here. And this is Hartford Avenue. This is the glass company, and the train tracks were back here on the other side of this grassy area, or not grassy, but with vegetation.
And when you described that you were searching on the 6th, or in June, what area did you first focus on?
When we went out there with the cadaver dog, it was this area. We went further down and started at the end where the tree started and came down. And once the additional call came up where everybody kind of left because we had not found anything, we were standing at this intersection, the dog handler and the 2 railway policemen, when the gentleman came out and he told us about coming back here. I believe this may be a more modern picture because there were no houses. The houses were down here at that time.
And that's where you found the remains.
Correct.
You can have a seat. Thank you. I'm showing you what's been marked as State 64. Is that familiar to you?
Yes, it is.
And, could you describe it?
They're black trash bags that are in the wooded area.
And I'm also going to show you what's been marked as State 65. Is that familiar to you?
Yes, it is.
And what is it?
It's another black trash bag in the wooded area.
And are those fair and accurate representations of how you found things?
Yes, yes, they are.
Your Honor, at this time, I'd ask states 64 and 65 be entered in or admitted into evidence.
Mr. McDermott?
No objection.
64 and 65 are admitted.
Thank you. And I'd like permission to publish these.
Go ahead.
Thank you. Okay, as you can see on there, where was this found?
It was in that wooded area.
Was that off the path, or when you answered earlier questions about being on path or off the path? Do you recall where those were found?
This was off the path.
Do you recall what were in those bags?
No, I don't.
But those were relevant?
No, there were remains in the bags that were collected by the medical examiner's office.
But that's how they were found.
Correct.
Show you states 65. Okay. And what is that
That's
picture describe?
another bag that was in that area, and I'm not sure if that's the bag that had the foot in it, because I really can't tell. If I got up and looked closer, maybe. I can't tell, but there were remains in the bag.
Would you like to take a closer look at it?
Yeah, I'm not going to be able to
Okay.
tell.
And where was that bag?
Again, in the wooded area.
The same general area?
Yes.
Nothing further.
Any questions on those questions, Mr. McDermott?
No, Your Honor.
Thank you, ma'am. You may step down.
Thank you, Judge.
State may call its next witness.
Your Honor, the state calls Tina Pett.
Stand. Before you have a seat, if you'll turn and face the deputy and raise your right hand, he'll swear you in.
Yes, ma'am. Do you swear affirm that testimony you will give is the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. You will not see.
When you do, just be careful of that ledge because your chair's on wheels.
Yeah, I see that.
Get yourself situated, move up to the microphone. and
Thank
if you'll
you.
State and spell your name for my record, please.
Okay, it's Tina Mae Patton, Patton.
Yes. Ms. Patton, good afternoon.
Hey,
All right. Can you tell the court what part of the county, where are you from?
I'm from Henry County.
All right. And are you familiar with the name Melissa Wolfenbarger?
Yes, sir.
All right. How do you know Melissa Wolfenbarger?
She's my sister.
Okay. Do you have any other siblings?
No, just her.
All right. And is that your biological sister?
Yes.
Can you talk about where you and your sister, Melissa Wolfenbarger, grew up?
Well, part of my life, we were in Ellenwood, Forest Park area. And then the other part, most of the time when Melissa was in school, we were in Stockbridge or McDonough, Locust Grove.
Okay. How many years did you live in the same household with Melissa?
Until I was 18 when I left.
Okay. And are you the same age as Melissa, or you guys different ages?
No, she's younger. There's
Okay.
7 years in between me and Melissa.
All right. And who lived with you and Melissa in your residence growing up?
It was me, Melissa, my dad, well, our dad, and our mom. And for a little while, our granddad on my dad's side, Papa,
Okay. And what is your mother's name?
Norma,
And what's her last name?
Patton,
And what is your father's name?
Carl Patton.
Okay. And were your mother and father together throughout
Sir.
your childhood?
Yes, sir.
Okay. And what type of relationship did you have with your sister growing up?
Well, there were 7 years between us. So we were doing different things at different ages. I mean, there were 7 years between us. So when I was 7 and was out playing and stuff, she was a baby. So we wasn't that close. I mean, we lived in the same house and we played outside and stuff, but we wasn't like 1 year between us that kind of close.
Okay. And do you live with anyone now?
Just my husband.
Okay. Now, you said that you lived in the same household with Melissa until about 18. Is that correct?
I was 18 when I left.
And what did you do? What did you do, and where did you go when you left the residence?
Well, at 18 when I left, I was in Stockbridge probably for about a year with my dad's Aunt Marie with her daughter, Elaine. I lived with her for a little while. And then after that, I ended up in Las Vegas, actually, Nevada, and
Okay.
had my son out there.
All right. And when do you make your way back to the Georgia area?
When my daughter was, let's see, she was born in 90, so probably about February of 91, we came back to Atlanta. Well,
right.
I came back to Atlanta with both my kids.
All right. So it's February 91. You left at 18. Roughly how many years has passes between those two events?
3 years.
All right. During that period, did you keep in contact with your family members?
Yeah. Melissa came to Tucson, Arizona and lived with me for a little while
Okay. All right.
before I had Kimberly.
All right. That would have been during that 3-year period? Mm-hmm. So from, say, 18, 19 to mid-20s? Mm-hmm. All right. And so when you came back, did you live by yourself or live with someone else?
No, I went back to Mom and Dad's house.
All right.
And Melissa was still at home.
All right. And so you're about, say, mid-20s during that period?
2021.
All right. How long did you stay at the residence with Melissa and your mother and father?
I stayed there pretty much until probably late 94, probably when I left again.
Okay.
But I'm thinking about 95 because 95 was when I got married to my first husband, David. And that was in early 95 though.
Okay. How long? It's okay. All right.
So it was probably about October or so of 94, I guess,
All right.
when I left.
Were you employed and working anywhere during that
I
period?
wasn't working. I was pregnant at that time.
Okay. And at some point, did you start working?
When I went back home,
And where did you start working?
Waffle House,
All right.
again.
All right. How many years did you work at Waffle House?
Off and on for about 20.
Okay. And during that period, while you've been employed at Waffle House up until the time that she disappeared, did you keep in contact with Melissa Wolfenbarger?
Not, I was kind of mad at my parents. Well, more mad at my mom. I was upset with my mom. So I really didn't call home much, but all of a sudden one day somebody comes up to me at Waffle House and says, "Guess who you're going to be training tonight?" And I'm like, "Who?" They said, "Your sister." And I'm like, "What?" And she was married then. She was already married to Chris.
Okay. And what year was that, if you can recall?
97.
Okay.
Yeah, 97.
So that was roughly the year before she disappeared? All right. So what type of work would Melissa do at Waffle House?
Well, she worked third shift with me. She was a server.
Okay. You recall how long she worked at that location? And what location was that, if I didn't ask you that?
It was close to the airport, Virginia Avenue, next to where Spondivus is. So the corner of Virginia Avenue and Bobby Brown.
All right. So roughly about 3 months, do you recall the time period?
Probably about 6 months because she had gotten her vacation pay. And Waffle House, you get a vacation check every 6 months.
Okay. All right. Are you familiar with Christopher Wolfenbarger?
Yes.
How do you know Christopher Wolfenbarger?
He was married to my sister.
Do you recall at what point in your life you met Christopher?
Yep. It was 95 when I got married.
All right.
The day I got married actually was the first time I ever met him.
And were the defendant and your sister in a relationship at that time when you met him?
Yes.
Okay. And do you recall how long they were in a relationship when you first met him?
No. Because, well, it wasn't. It had been a while, I guess. Because when she came to work with me at the Waffle House, they were already married.
All right. How many?
It was 95 when I first met him, January.
95, and do you recall how much time passed between you first meeting him to when they got married?
Probably about not too long. I think it was only a month or two.
Okay. Did your sister and the defendant have any children?
Yes, they had two.
Do you recall their names?
Christina and Joey.
All right. Did you get an opportunity to spend time with them as they were growing up?
No, because I was working all the time.
All right. Prior to the defendant and your sister getting married, how much time would you say you had a chance to spend around him?
None.
Okay.
None.
After they got married, how much time would you say you had an opportunity to spend around the defendant and or your sister?
I spent more time with her than I did him.
Okay.
The only time I ever saw him was when he would come up there to the Waffle House to drop her off or pick her up.
All right. If you saw him in court today, do you think you could recognize him?
Oh, I know his face very well.
Okay. If you could point to
He's
Christopher Wolfenbarger.
Right there, black hair and the gray suit.
Okay. Thank you.
If you would, ma'am, sorry, but for my court reporter, if you'll, you're fine so far, you don't need to repeat
Okay.
anything, but if you'll let the lawyers finish their questions all the
Oh,
way.
sorry.
Before you start to answer, thank you.
Got it.
Go ahead.
Okay. Your testimony was that Christopher Wolfenbarger would visit the Waffle House, Virginia Avenue near Spondivus.
Yes, sir.
How many times do you recall him doing that?
All the time. Every time she had to work.
And what would you see him doing during that period?
Most of the time, just watching what she was doing.
And are you familiar with the name Troy McClendon?
Yes.
Who is Troy McClendon?
Troy was my boyfriend at the time when I worked at that Waffle House with Melissa.
All right. And did you ever see Troy at the Waffle House?
Every day. He worked the same shift that me and Melissa worked, third
Okay.
shift.
Can you tell the jury if Troy was ever at the Waffle House at the same time that Christopher Wolfenbarger was at the Waffle House?
Oh, yeah.
Okay. And do you recall a confrontation between Troy McClendon and Christopher Wolfenbarger?
Yes, I do.
Now, without repeating anything that that anyone else said during that encounter, can you tell us what you observed happen?
Melissa was running late this time. She was running late getting there, and I was standing in the back by the office door, just looking out front, watching what was going on, because it wasn't time for me to go out front yet. The manager was counting the money for us to take out, and Melissa came in. She came through the swinging door at the back where I was, and I looked at her, and she had tears in her eyes. And her nose was red, her eyes were red, because that's always how she got when she was crying. We all do when we're crying. And everybody in my family anyway. And I noticed that she had like red marks around her throat. And I said, Melissa, what's wrong with you? What's going on? Wait a minute. Is that a handprint around your throat? And she just looked at me and her eyes filled with tears. And I said, did Chris do that to you? And she just looked at me. She didn't really say nothing. And then I just turned and was going to go out the door. I was going to go say something to Chris.
Okay. Did you?
She wouldn't let me. She stopped me. She said, you'll make it worse.
Can you tell the jury what happened after that?
I went out front. Troy evidently heard me in the back room saying something to Melissa, so he was coming towards the swinging door when I was going out it. He said, what's going on? I said, he hit my sister again.
What happened after that?
Troy went over there and confronted him and hit him, and he just looked out the window.
I'm sorry?
Chris just looked out the window.
Okay. How long did that continue?
Not long, because one of the other employees came and grabbed Troy and pulled him away and got Chris out the door.
Okay. Now, what period of time, if we're trying to orient, you started, I think you said during that 6-month period during 1998.
Sorry.
Okay. So if we're looking at that beginning of 1998 period, can you tell the jury, as best you can, when did that happen?
That was more towards the end of 97.
Okay. Now, is that the only confrontation with Christopher Wolfenbarger that you can tell this jury about?
And that's the only one with Troy.
Okay. Did you end up having another confrontation with Christopher
Yes, I did.
Wolfenbarger?
I did.
All right. Can you tell the jury how that happened?
Melissa had come and stayed with me for probably about a week. It was supposed to have been longer than that. So we would sit up at night talking about stuff, and then all of a sudden she decided she wanted to go home because the kids. So I took her home, and she was getting out of the car, and I was getting out with her, and I was going to hug her to tell her goodbye. And he came out of the house, Chris, and was coming down the steps, and he called me a bad name. He called me a B. And I started going up the steps. He said, if you put your hands on my sister again, I will beat your butt. And she grabbed my arm and said, Tina Mae, shush. You're going to make it worse. She always said I would make it worse.
Okay. Did anything happen after that?
No.
Okay.
She quit after that.
And around what time period was that?
That was within a month after the confrontation with Troy. So about a month.
Okay. Okay. Now, I want to turn your attention back to at the time that you were working at Waffle House with your sister. Can you tell the jury if anything you can recall about what the defendant told you that what might have been a cause for concern with you, especially considering the disappearance of your sister?
As far as what she said?
Did you have any conversations with the defendant, or did you overhear the defendant make any statements about anything in particular that was of concern for you?
Yeah, We were sitting having breakfast one morning, me, Melissa, Chris, Troy, and there was another waitress sitting there, Diane. She was a friend of mine. She'd been working with me for a while, and we were all sitting there eating breakfast, just having a conversation, talking about whatever. And then all of a sudden, Chris pops off with, well, I know how to get rid of a body if I need to. And me, Diane, and Troy looked at each other like, what? Because we were just talking nonsense about silly little stuff or about the news of the day or whatever, just cutting up laughing. And then all of a sudden, this comment comes out of his mouth.
Okay. And your testimony is you don't recall the context or what happened or what was said before that.
Well, that was the thing. It wasn't like we were talking about being mean to somebody or killing people or nothing. We were just sitting there cutting up about little silly stuff, and then all of a sudden this comment comes out. And we're all like shocked because it's like, where did this comment come from? Why would he say something like that?
Okay. At any point, did you ask the defendant about that statement?
Oh, no.
Okay. Do you recall if anybody else asked him about it and if there was a response from him regarding that?
No, nobody said nothing. Everybody was just surprised, shocked.
Okay. Now, if Melissa stopped working, you said after that 6-month period at Waffle House, did you see her again after that?
In March, for
Okay.
my birthday.
All right. And what year of March was that?
98.
Okay. All right. So, and would that have been the same time that she would have ended her tenure at the Virginia Highland Waffle House?
I didn't know that she was working at that one because when I saw her that night, she told me she was working at Doryville.
Oh, okay. All right. But was that after she had left the location she was working with you? I'm trying to make
Yeah.
sure. Okay.
Yeah.
All right.
You said Virginia Highland.
Gotcha.
We were on Virginia Avenue.
One moment, Judge. Let me turn your attention back to you were talking about a period of time when Melissa and the defendant were, when you came back, they were in a relationship, but it was before they were married. Mm-hmm. And you have to give a verbal answer. So was that it? That was a yes?
Yes.
Okay.
Sorry.
No problem. Do you recall when Melissa left the residence?
That I don't.
Okay.
That I don't. I don't know when she actually left from home. I know in 95, when I got married in January, she was still at home, but they were dating at that time.
All right. Now, have you, let me ask you this. When was the first time that you had a concern about the whereabouts of your sister, Melissa?
When my dad walked into the Waffle House in February of 99 and asked me where my sister was.
Okay. Why was that a concern for you?
Because Mom, it was right after Mom's birthday. Mom's birthday is February 24th. If my sister didn't go see my mom, call my mom, or send her a card for my birthday, then something was wrong. Because Melissa always called Mom or got in touch with Mom or something on her birthday. Always. She never forgot Mom's birthday. I did. but she always remembered Mom's birthday.
Okay. And so this is February of 99. After he comes into the restaurant, what do you do after that?
Nothing. I just was like, I was surprised. I remember I called my grandmother and asked her why Dad was looking for Melissa. Because at the time he came in, it was lunchtime, so I was kind of busy. So I couldn't really sit down and talk to him and have a long conversation about what was going on. He just came in and said, "Where's your sister?" And I was like, "I don't know, why?" He said, "Well, I went to go look for her and I can't find her nowhere. Nobody knows where she is." I said, "Well, Dad, she doesn't work."
Just a moment, ma'am. Mr. Bossett.
I can move on with the additional questions.
And just as a reminder, ma'am, we generally, unless we're asking you to not necessarily tell us what other people told you, unless we specifically ask you about that, okay?
Okay.
Thank you. Go ahead, Mr. Bossett.
At any point, do you make any efforts to locate Melissa?
Well, I knew that they were looking, so I myself didn't.
And when you say they, who are you referring to?
Mom and Dad.
All right. And specifically, did you make any attempts to reach out to law enforcement or anything of that nature?
I did, but it wasn't until 2015.
Okay. And how did you go about that process of reaching out to law enforcement in 2015?
Well, the thing is, in 2015, you know, there was a lot of the ID discovery shows. I kind of got addicted to them, and we already knew by then that Melissa had passed. So I kind of got angry, and that's when I really started trying to reach out to them and push.
Okay. So these are shows where crimes are being solved?
Uh-huh.
Okay. All right. So you started trying to reach out. Who you started trying to reach out to?
City of Atlanta, or anybody that would listen. Nobody wanted to really talk.
All right. And are you aware of any investigator was working on that case at that time?
It was Calhoun at that time.
All right. How did you come to find out about the particular officer involved?
Actually, Calhoun, we had already talked to him before that. It was, I think, 2003, I think it was, when we talked to him.
Okay. And 2003, was there anything else of significance that happened in 2003?
That was when we found out that she was dead.
Okay. Well, anything prior to that?
That was the same time that my dad was arrested.
All right. And what was he arrested for?
Murder.
All right. And so, your dad's arrest for murder, does that happen before or after you find out that Melissa was the identity of the remains?
Actually, it was the same time
Okay.
that I was notified.
I see. Okay. But do you recall that as being the same year?
Yeah.
2003?
Same year, same day.
All right. And from that 2015 period up to, I guess, the point that we are now, did you make any additional attempts to contact law
Oh,
enforcement?
yeah. I
And
tried.
Who did you contact, and how many times did you try to do that?
Every time, well, 2015 was when I decided I was going to get the folder, the file on Melissa.
I'm sorry, what was that?
I was trying to get the file on Melissa.
Okay.
On the case. I had problems getting it. I filed the Open Records Act probably 3 times. And they kept sending me emails back saying, no, they couldn't find the file. There wasn't a file.
Okay. And how many times did you attempt to do that?
That was 3 times then.
And what agent? You said Atlanta Police Department you were attempting? Mm-hmm. Okay. All right.
Yes. Sorry.
All right. Did you do anything else besides that? Try to get the open records request?
Yes. After the 3rd time, I had come down here the 3rd time in person and filed it. I'd already talked to somebody with Henry County Sheriff's Department that came to the restaurant where I ate at. And he said, well, if there's a file. Okay.
You can't say what someone else said.
Yeah.
He just gave me a suggestion about what to do about the file.
All right.
I'm going to object to relevance, Your Honor.
I'm going to allow it. Overruled. Go ahead.
Okay. Did you reach out to anyone that wasn't with law enforcement?
Yes.
And
Well, no, she's really with law enforcement.
okay, all right. And did you continue to do that throughout that period of 2015?
Anybody who would listen to the story I told.
Did you conduct any interviews with any reporters or anything related to this story?
Of course.
Okay. And what was the point or purpose of you doing that?
Getting Melissa's story told.
And why were you trying to do that?
Because we wanted answers about her murder. We wanted an arrest.
Okay. Now, did you and Melissa have any conflict as you were growing up?
Of course. I mean, we were sisters.
Okay.
There's always some kind of conflict.
All right.
Nothing life-changing.
And the two instances where you were testifying as to the encounter that you had with the defendant at Waffle House and then at the residence, is that the only encounter that you had with this defendant?
Yeah.
All right. That's all I have, Judge.
Thank you. Mr. McDermott?
You've spoken to the press and media a lot of times, haven't you?
Of course.
One of the things you've said is you've described how you and Melissa are kind of polar opposites.
Yes.
Uh,
We were.
She was a quiet, shy, reserved.
Yes.
And you are not quiet, shy,
Right. No, not at all. I'm
You
pretty
describe yourself
outspoken.
a little bit more rebellious
Yes.
when you were younger. Did you describe a period earlier that you had left for a couple of years and didn't talk to your mom?
Yes.
And you previously told detectives that you couldn't talk to your mother. You just didn't get along with her.
I didn't get along with her for quite a while.
Okay. You described yourself as a daddy's girl
I was.
and Melissa as a mama's girl.
Yeah.
Okay.
Exactly.
Now, let's just talk about this briefly. You've been in a little bit of trouble yourself too, haven't you?
Yes.
You were most recently convicted for possession of methamphetamines, is that correct? That was in 2021?
Yes.
And did you have a similar charge in 2022 or 2020?
Yes.
Okay. Did you have previous drug charges before that?
No.
Okay. Do you remember telling Detective Calhoun that Christopher worked for your dad at one time?
He did.
Would that have been a very, well,
Very short time.
it was a very short time, but it was very early in their relationship,
Yes.
wasn't it? What did you say, like 95 or so?
No, probably before that.
Okay. And what did Christopher do for you?
Well, my dad was a roofer.
Okay.
He had a roofing company, so
He spent a good bit of time up on the roof then, didn't he?
yeah.
And Christopher would have been there with him.
Yeah.
And so Christopher would have spent a good bit of time with your dad at that time,
Probably.
for however long it lasted.
Yeah.
Okay.
But a lot of times Dad would go to other job sites and stuff too.
Now, you just described that you didn't know to be worried about Melissa until your dad came into the Waffle House where you worked.
Yes, sir.
And you said that was in February of '99.
Yes.
And that would have been right after your mother's birthday, is that correct?
Right.
And did your mom and dad come up there together?
No, it was just Dad.
Just your dad? And that's when he asked you about where's your sister? Mm-hmm. And
Yes, sir.
she didn't call it Christmas,
Right.
and she didn't call for your mom's birthday.
Right.
And that's when you said, wait a minute, something's wrong.
Right.
And What did you do after that?
I waited to see if Mom and Dad would find her, because that's what they were going to do. They were going to look for her. I was working night shift. It was hard for me to look for her.
And it was hard for you to look for her. And how long was it before you actually did start to look for her?
I couldn't look for him by the time 2003 came around and we found out she was dead. It wasn't until later that I started trying to do something.
I see. Do you remember saying to Detective Calhoun that after Carl came up to look for you at your old Waffle House, you went up to Brookline?
No.
If I
That
showed,
was way before that I went to Brookline.
if I showed you a transcript of your interview with Mr. Calhoun, would that refresh your recollection?
Probably.
Yeah, approach her.
Yes.
My apologies for the small print.
Very small.
I think it's
Maybe. But I have glasses on, so it's okay. Oh, yeah. Okay.
So does that refresh your recollection?
Yeah, it does.
So you did go up to Brookline after your dad came.
Yeah, because Dad wasn't exactly sure. He had a different address for him than where they actually were. I think the address he had for him was Washington Avenue, I think. It wasn't Brookline.
Do you remember also telling Detective Calhoun that when all this stuff first happened, I went up to the West End to Brookline and knocked on the door?
Before what happened?
Those were your words. You talked to an aunt or a cousin there?
Aunt or a cousin? No, I never talked to an aunt or a cousin.
If I showed you a transcript, would that refresh your recollection?
Yeah. Where?
You do not. Thank you.
I don't remember that. No, I don't remember that.
That doesn't refresh you?
No, I don't remember that.
You deny saying that?
I don't remember saying that.
You deny?
I know that I don't remember ever knocking on a door and a cousin or something like that answering the door.
You remember that house?
I know I went to Brookline after I saw my dad.
Do you remember the house that Christopher and Melissa lived in was a duplex?
Yeah.
And that their relatives lived in this second?
There was a uncle or something that was deaf that lived on one side of Chris and Melissa.
So do you not deny
blind.
making this statement that you talked to somebody at the house?
I don't remember talking to anybody at the house, but I know I went to Brookline, but I don't remember saying to Calhoun that I talked to somebody.
Okay, I just need you to focus on my question. I know you don't remember now, but I'm asking, do you deny saying it?
Hang on, there's an objection, so just one moment.
The witness has answered the question. He's demanding an acceptance or denial. She simply stated she doesn't recall. So I don't think she's in a position where she's ready to say, I deny it, because she doesn't remember. She doesn't remember.
I'll move on.
Answered the question.
I'll move on.
Mr. McDermott,
I'll move on.
go ahead.
Do you remember Detective Calhoun asking you about your father, and could he have had anything to do with Melissa?
Yes, I do.
And do you remember saying, no, he's mellowed out as he got older?
I don't think that was exactly what I said, but I know I told him that there was no way it had anything to do with my dad, and that my dad would not do that. Actually, I took offense to it.
Do you remember also telling Calhoun immediately after that you and your sister and your mother were the most important things in his life?
In whose life? My dad's?
Yes.
Yeah.
And do you remember saying that he would kill anybody for you?
For us, yes.
If anybody was messing with you, they were gone?
Yeah.
That was all it was. And do you remember telling Calhoun it didn't matter who it was?
That's true.
Does that sound like a man who had mellowed out?
Your Honor, objection. The question initially was speculative in nature, or was asking a speculative question. I think he's coming back to what she thinks her father could or could have done, and I'm objecting to the form of the question.
I'm going to sustain the objection to the form of the question, and you can rephrase it, sir.
I'll move on, Your Honor. You have stated that through the period that you knew Melissa at the Waffle House and whatnot, that you worked hard to get Melissa away from Christopher.
Yes, I did.
And you said that you didn't like him,
No.
and that nobody in your family liked him.
No, we didn't.
Do you remember saying that to Detective Calhoun?
Yes, I do.
Do you remember telling him, do you remember saying on a podcast that Mom and Dad don't even know how much I tried to get Melissa away from Chris behind closed door?
Yes, I do.
And you did all that while you were working at Waffle House. And you persuaded her to come live with you for 2 weeks, right?
Right.
And you said just a while ago on direct testimony that you claimed that she left your house because she wanted to go see her kids.
She wanted to go back home to her kids after a week.
After a week. And that's when you took
Must have
her,
been 2 weeks.
and you took her back up to Brookline.
Yeah.
And are you aware that her kids didn't live with her at Brookline?
They were always there when I went. Anytime I saw her at Brookline, they were there.
You were aware that at that time she didn't have custody of those children?
No, I wasn't aware of that.
Do you remember? Do you remember Detective Calhoun telling you that she didn't have custody of her children at that time?
Yes, sir.
Hang on, just, yeah, thank you.
Objection. Yes, sir, Judge. Your Honor.
Mr. McDermott, response?
It's not being offered for the truth of the matter asserted. It's being offered to her recollection that it was said to her and what her reaction was.
I'm going to overrule the objection. Go ahead.
You remember telling Detective Calhoun that she wouldn't just up and disappear on her kids like that.
I do remember saying that.
And he told you she didn't have custody of them.
I don't remember that exactly. But I know he said something to me about the kids.
If I showed you a transcript of that discussion, would it refresh your recollection?
Yeah. Where? Okay. But I didn't know that.
And this interview was in 2003, correct?
Yes.
So you've known since 2003 that she didn't have custody of her children, correct?
That's what I was told.
So
And I learned.
your testimony here today still is that you took her back to Brookline so she could see her children.
That's what she told me she wanted to go back to Brookline for, was because of her kids.
Because of her kids. Okay, thank you. You said that Melissa was actually close to Troy, your boyfriend.
No.
Do you remember telling Detective Calhoun that that was one of the few people she was close to?
No, I don't remember saying that. If I showed you a transcript of that, would it refresh your recollection? Yeah. Where? Not really.
Do you remember telling Detective Calhoun that she was also close to your husband David at the time?
I kind of, a little bit remember that. Something about David.
Is that David Burns?
Yeah.
And where is he today?
Hopefully in jail
And why was he sent to jail?
for molesting my daughter.
Do you remember, obviously I've asked you several times if you remember talking to Detective Calhoun in 2003. Do you remember in that interview that he asked you when was the last time you saw Melissa?
Yeah.
Yeah. And do you remember telling him, similar to the story you told here a while ago, that it was in March on your birthday?
It was March, the same week of my birthday.
The same week of your birthday. And you remember that clearly because
Because it was my birthday and she brought me a cake.
and she brought you a birthday cookie.
Yep.
And you worked at the Waffle House by the airport, and the WWE wrestlers came in on that night.
Yeah. I remember that.
And you and Melissa were both WWE fans.
Yeah.
And you said, but she just missed them that night.
Yeah.
Okay. You remember telling Detective Calhoun that that was in March of 1999?
I don't remember saying 99, but I was probably confused about the year because it was 98. 99 was when she was found.
But you agree with me that she was not found until April 29th?
Yeah.
But do you remember having that conversation with him that your mother had told you it can't be 99, it had to be 98?
I think that was later on when me and Mom were talking, because at that time I don't think me and Mom were really talking that much.
If I showed you a transcript, would it refresh your memory?
Yeah. I do remember her telling me that one time.
And that was before the interview with Detective Calhoun, obviously.
No, I think that was not before the interview. I think that was later on. I think she said something to me about it.
If this is a transcript of the interview with Calhoun, and you're telling him about your mom talking to you before that interview,
Mom wasn't with me that day. I went to see Calhoun by myself.
and when you're talking to Calhoun, you said, I talked to my mom yesterday. Isn't that what you just read?
Yeah, that's what I just read, but I think that was a different time.
Do you think,
Different time that I talked to Calhoun. That wasn't the first time that I talked to Calhoun.
but now I'm confused. You gave multiple interviews to Detective Calhoun?
I talked to Calhoun several times.
And this was in 2003, correct?
Right.
Okay. So, as of this interview, you were telling him that you were certain that it was March of 1999, but that you had talked to your mom the day before and she was trying to get you to change your mind. Is that what you just read?
That's what.
You grew concerned about Melissa when your father came into the Waffle House in East Point in February of 1999.
Is that a yes?
Yes.
Thank you.
Sorry.
So you were working there in that time frame.
At a different Waffle House I was. I was at a different Waffle House when Dad came to see me.
You just testified.
At Waffle House. But it wasn't the same Waffle House we worked at.
Okay, I'm going to go back and ask you again for the record. Do you remember stating on a podcast I didn't get concerned until I was at work one morning at Waffle House in East Point. And here comes my dad walking in the door,
Yeah,
talking about where's your sister?
Yeah.
And that was in February of 1999.
right.
Okay.
What's the question?
Well, I thought you just told me that you were working in a different Waffle House
I
when this
was.
happened.
It was the one in East Point, but that wasn't what you said earlier.
So you were working at the Waffle House in East Point at this time?
Yes,
Okay,
Washington Road.
that was my question. And is that where Melissa came to see you?
No,
What Waffle House was that in?
Virginia Avenue,
Okay. And where's the Waffle House in East Point at?
Washington Road.
Washington Road. The one by Spawn Divots.
No, that is Virginia Avenue.
Okay.
It's also East Point. There's two East Point
East Point
applications,
Waffle House. I see.
locations.
When you saw Melissa leave that night, the last time you saw her, was she by herself or with somebody?
She was by herself.
And how did she leave?
She just left in a car.
In a car? Do you remember telling Detective Calhoun she was in a white Ford pickup?
It's possible. They only had two vehicles that I ever saw.
And she was driving the vehicle?
She was driving it.
Do you know who owned that vehicle?
Probably Chris.
Do you remember telling Detective Calhoun that that car was in her name?
There was another car that I think I said was in her name. But that's what she told me.
If I showed you a transcript of that discussion, would you refresh your memory?
I said, I think.
Did you tell Calhoun at that time that you think it's in Chris's name? Or did you tell him that you think it's in Melissa's name?
Well, it says there that I thought it was in Melissa's. So that's probably what I said, but there was another car that was supposed to have been in Melissa's name.
Now, you just told us about an altercation that allegedly occurred between Troy McClendon
Thank you.
and Mr. Wolfenbarger. And you told it a little different than you did the first time. Or at least as you told Detective Calhoun. And I'd like to walk through some of those details.
Okay.
When you testified a while ago, you said that she came back, they came into Waffle House together, is that correct? Melissa and Chris?
Is that a yes?
Yes.
Thank you.
And Melissa walked to the back with you. And she was in tears.
Yes.
And you noted these handprint marks on her neck.
Right.
And you said to her, did Chris do that to you?
Yeah.
And she didn't say anything.
Right.
And you said you went to go do something and she stopped you?
Yeah.
What were you going to go do?
I was going to confront Chris.
Okay. Do you remember telling Detective Calhoun a different version of that story where you asked her, what's wrong with your neck? And she said, Chris tried to choke me.
Probably. I don't remember exactly. That was a long time ago.
But you're testifying under oath here today that she didn't say anything back.
I'm sure when I was walking away, she was trying to stop me, which she would have said something.
But she didn't say anything back when you asked about the neck.
She cried. She didn't have to say anything.
But you told Calhoun that she did respond to you. correct?
I guess. I mean,
And you said that as you were starting to come out the back, Troy McClendon was coming through the swinging doors to the back.
yeah.
Yeah. And when you talked to Calhoun, you said you were coming outside and Troy was just coming in the front door.
No. That wasn't what I meant. There's one swinging door between the front and the back. You have to go through
So
that.
you're referring to the front as just the restaurant part?
Right.
Okay. And you remember telling Calhoun that when they came in, Chris sat down at the high top.
No, he sat down in a booth.
If I showed you a transcript, would that refresh your recollection?
Is that a yes?
Yes. Oh, okay. That was when they were coming in the door. When they had come in.
So when they came in, Chris sat down at the high top, correct?
Yes, so.
And for those without Waffle House lingo, the high top is kind of the bar with the tall stools.
Yes.
I don't need to explain that to an Atlanta jury, I'm sure. But then you said when you came out, you talked to Troy, and then Troy went to confront Chris.
Right.
And then he went over and Chris was in a booth by the window.
Right, because he had moved.
And Melissa was in the seat beside him, correct?
No, Melissa was still in the back. Melissa wasn't out front yet.
If I showed you a transcript, would that refresh your recollection?
Mm-hmm. Other side of the booth. Okay, yeah.
On the outside of the booth, is that correct?
The other, I probably said that outside,
Other side of the
but
booth.
she was on the opposite side of the table from Chris.
How did she transport from the back suddenly to the table?
Because she went out the back door to go out front. She went the opposite way of where I went. I went straight to the front. She went, there's another door behind the office that goes to the restrooms.
Okay.
So she would have went out that door and went out front trying to beat me to the front. But Troy had stopped me.
And he had to reach across Melissa to slap Chris, is that correct?
He reached across the table to slap Chris.
But he had to reach across Melissa.
I don't remember Melissa sitting on that side. I think it was the other side.
Okay. So you've told different versions of this story, different details as time's
It
gone
was
on.
a
haven't you?
long time ago.
Yeah. You've also told us this story that Christopher just one day blurted out at Waffle House, he knows how to kill somebody and get away with it.
He did.
And you said you had no idea where that phrase came from.
No.
But didn't you just tell us that Christopher used to work and spend the day on the roofs with your father?
And
And your father was convicted of murders he committed back in 1970s?
so my
And he used-
dad never said anything like that.
How do you know? Were you on the roof with Chris?
My dad would never say anything like that.
I'm asking you, were you on the roof with Chris?
No, I wasn't.
I'm objecting. I believe this is argumentative against the witness.
Overruled. Move on, please.
So, just one more time. You were never on the roof with Chris.
No,
You weren't there when he spent time with your father.
no.
And you don't know what your father might have boasted about.
My dad never boasted about what he did.
Not around you, correct?
They never talked about what he did.
You can only talk about what you know, correct?
I know my dad never talked about what they did.
All right. Excuse me, no further questions.
Thank you. Anything else for this witness, Mr. Fossett? Redirect.
Ms. Patton, When you confronted Chris at the residence, you were testifying previously to dropping Melissa off at the residence. What residence was that?
Brookline.
Okay. And that was still during that 1998 period? All right. And that,
Yes,
Yes.
thank
Sorry.
you. That's okay.
all right. And if we're talking about the year she was found, the year her skull
sir.
and remains were found, you recall that as being 1999?
Yes, it was.
All right.
99.
Now, if you could, to the best of your recollection, think back to that period of time when you were working with your sister, and I get the Waffle Houses confused myself, and that's the Virginia Avenue Waffle House, is that right?
Right.
Okay. What year was that?
It was 97 when she worked with me.
All right. And was that the beginning of 97?
It was the end of 97.
Do you recall if it was December, November, October?
Well, it was the end of December. It was the end of the year, but it was March when she came to see me of 98, and she had already left that Waffle House.
All right. And your testimony was that she left right after she got the 6-month vacation check?
Right.
So if she started at the end of 97, would 6 months have taken us to the end of 98?
No, I think it was, how can I explain it? If she started in like September, then would have been September, October, November, December. There would have been 4 months right there. By the time my birthday got there in March, she had already left that Waffle House because she was at the one on, what was it? Doraville. She
So-
told me she was at Doraville.
So she would have left, or I guess started early enough in 97 to hit 6 months
Right.
before your birthday in March.
Right.
Okay. Now, you were just testifying as to the events that occurred at Waffle House.
Right.
You just testified about the booth, about the high chair. Have you seen, like you would show the transcript, before the defense attorney showed you a copy of your statement,
Right.
the multiple statements.
Right.
Had you seen those transcripts prior to today's date?
No.
You hadn't studied those transcripts?
No.
And we're talking about events that occurred in 1998?
Right.
And are you still testifying to the best of your recollection?
Yes.
All right, that's all I have, Judge.
Mr. McDermott?
No further questions.
Okay. Thank you, ma'am. You may step down. The witness excused. May the witness be excused?
No objection.
No objection.
Okay, go ahead, ma'am. Counsel, can you all approach for a minute? It's 5:15, and so we're going to adjourn for the day. I have a couple of pieces of instruction for you and requests. Let me start by telling you that I need you to be back here tomorrow morning at 9:30. And you'll just follow the same procedure that you followed previously. Now you probably have a little bit more insight about going to the callbacks, and we'll let you into the jury room. So that's 9:30 tomorrow morning. A couple of things that are important. One is we can't proceed unless all of you are here together. So that means whether it's I'm releasing you for the evening or if I'm releasing you to lunch or a break, if you'll try really hard to come back at the designated time, especially if arriving in the morning, because we can't start until everybody's all here together. If you are running late, if something happens, if you missed the shuttle the first go round, that sort of thing, just let us know. Contact my office, send us a quick text or an email, and that way we'll know that you're on your way and that we can accommodate that. Last few things I want to let you know, especially now that you have heard some evidence in the case. I want to remind you that your obligation in this case is to make this decision only based on the evidence that you hear in this courtroom. And so that means that it would not be proper for you to drive by any locations, to go do any of your own research, to look anything up, to do anything like that. It also would not be proper for you to discuss this case with anyone or to allow anyone to discuss it with you or around you, and that includes amongst yourselves until I tell you to actually deliberate the case. Now, lastly, I don't know if there will be media about this case, but I know some of you, maybe more than others, have said you watch local news and that sort of thing. I'm going to ask you to please avoid media. Don't go look anything up about this on social media, and please avoid local media or national media if you can, just in case there is something about this case. Now, should you happen to accidentally encounter something, first of all, stop immediately. And then second of all, let me know that that happened. And probably it will be nothing, but we need to know about anything that you might have seen so that we can decide if any action needs to be taken. Finally, I appreciate your patience and attention to this process, and I will send you home for the evening and see you tomorrow morning at 9:30 a.m. Thank you.
All rise and observe.
And the jury room will be locked, so you can leave your notes and things like that in the jury room when you go home for the evening. Thank you all. You may be seated. Anything from the parties that you need me to take up before we adjourn for the day?
Two very short things.
Yes, sir.
One, we were given a rap sheet on a witness who maybe the first witness tomorrow.
It would not be the first one.
At some point tomorrow. This is the first I've ever gotten a rap sheet on her. Our entire knowledge of this witness is one sentence in a report that's, 183 pages long. So I don't know much about her. I have actually two requests. One, is there any additional information through interviews or whatever? Or is that one sentence all we're going to hear from her?
Regarding who is this person? I think that would be helpful.
It's a former neighbor who's going to say she heard them fighting. The opening statement seemed to have gone a lot further than that, which means there's some other interviews or statements going on.
Ms. Hilton?
Yes, and I can put on
Can you
the
tell me
record-
the name of that witness so
Yes,
our
we
record's
can.
clear?
In the discovery, I believe she's named Dorothy Jones.
Okay.
However, her name is actually Dorothy Cooley.
Cooley?
Cooley, Cooley.
Okay.
She resided on Brookline. She was a neighbor of Mr. Wolfenbarger. It appeared, and I'll apologize, I thought most of this information was in the discovery, so I'm going to apologize for not giving you all of this. So we found her yesterday, Your Honor, interestingly enough, at her job. I did take a moment to speak with her. What we believe her testimony will be is that she lived on Brookline, was a next door neighbor, knew Mr. Wolfenbarger for about 10 years. She would say, and this is not going to come out, but in full disclosure, that they would sit on the porch every day and smoke marijuana. But he was younger than her. She was a little bit older. She was familiar with his Uncle Rick, who also lived at that home as well. That over the course of some time, eventually she started seeing a woman come by the house. She may have saw a baby with this woman once or twice. That she would hear yelling coming from their home. That one time she may have heard like things breaking multiple times, and that she did see on one occasion a black eye. She was the woman was wearing glasses and had a black eye. So that's what she would testify to. I don't think she knew her name. She can describe her. She's familiar with what she looks like. I did show her a picture of Ms. Wolfenbarger to see if this is the same person that we're all talking about. She said she recognized her as the woman that she has seen with Chris. I think she has to work tomorrow, so she'll be here by sometime after 10, so I can make her available so that you can talk to her. But that is the synopsis of, I believe, the information she would provide.
The second thing is, because I was just given a rap sheet, I can't give them notice, pretrial notice, that some of these convictions are old, but she's got a lot. I'm trying to make my way through the cycles, but there are some felonies that are more than 10 years old, so I'm giving them notice now. I do plan to use those to cross-examine her.
Ms. Hilton?
You're right. I think that's fine. That she's given notice. Thank you.
Thank you. It seems like we're going to accept that as notice for now. Mr. Samuel, anything else?
I think I just remember the 1 o'clock thing tomorrow, or the 1:30 hearing tomorrow.
Yes, the 1:30 hearing.
Again, I'm not trying to take priority. If I can just, if maybe we could do lunch sometime around then.
Yeah, I don't know how long, Judge Emerson is usually pretty efficient.
He's going to be very efficient.
But my intention was to target breaking for lunch around 1:15, so that way the jury would be, occupied. You could go downstairs and do whatever you need to do and then be back. And then thank you for reminding me of that, because that might assist the state in having their witnesses ready to go as we proceed through.
I very much appreciate that.
Okay. Anything from the state?
Nothing from the state, Your Honor.
Okay. The only thing I will ask, and this is just a preference, different judges are different ways, but if you can stand up and say objection, hearsay, objection, argumentative, objection, calls for conclusion, objection, he's badgering the witness, let's keep it to a minimum, right? If we need to have a more fulsome discussion, then I'll probably invite you up here. I'm not going to say you can't make your record that you've made the objection and what the general grounds are. And if the answer is going to be a withdrawn or something, we can do all that. But let's keep our speaking objections. I don't think anybody's trying to get away with anything so far in terms of objections and responses, but let's keep our speaking objections and responses to a minimum. Okay? Anything else? Okay. We are adjourned. It is 5:22. I'll see you guys tomorrow at 9:30.
Right now.